not to be obsessed with buildings.
Ends topical questions. The next item of business is a debate on motion number 5535 in the name of Mark MacDonald on the High Hedges Scotland Bill. Members who wish to take part in the debate should press the request to speak button now. And I call Mark MacDonald, who is the member in charge of the bill, to speak to and move the motion. Mr MacDonald, you have 10 minutes.
Thank you very much, Presiding Officer, and can I begin by welcoming you back to your place. It's good to have you back in the Parliament with us. I'm very pleased to open today's debate on the High Hedges Scotland Bill. I'd like to thank the Local Government and Regeneration Committee for its detailed and thorough consideration of the bill. This consideration was supported by the Subordinate Legislation Committee and the Finance Committee. A great deal of work has gone into getting us to this point, and I'm also grateful for the support that ministers have given me in taking this work forward. This is the furthest that any high hedge proposals have got in the history of this Parliament, and a lot of work has gone into the bill to get us this far. Both I and those supporting me have met with a number of people and organisations from across Scotland and elsewhere. Tony Dixon from Hartlepool Borough Council and Simon McGinnity from South Tyneside Council, both of whom I met personally in December 2011, were able to provide me with a great deal of assistance in understanding how high hedge legislation has worked elsewhere. Ian Edwards and Elspeth Forsyth, Steve Milne, Robert Patterson and Eric Hamilton from the Scottish Tree Officers Group have provided much expertise and advice for me, both me and the officials supporting me, and I hope will continue to do so. I should also thank Joe McIndoe, the owner of the Mill Garden Centre in Armadale, West Lothian. Joe very kindly allowed me to use his garden centre as an excellent venue for the launch of the bill last October. And I'm also very grateful to the organisation Scott Hedge, who I know have been campaigning for many years for this legislation to be brought into place, and they have engaged positively with me throughout the process. Let me make clear at the outset that this is not an attempt to define the height of every hedge in Scotland. There will be many people who own or live adjacent to a high hedge and have no issue whatsoever. I am not seeking to create disputes where none exist, but I am looking to resolve existing disputes. And it is clear that there are a number of intractable disputes which revolve around the presence of a high hedge. The problem that exists is that there is presently no way to resolve these disputes if there is an unwillingness to resolve them amicably, and I have sought to provide a mechanism to remedy this by introducing this legislation. The Scottish Government consulted on this matter in 2009, and that gave an indication of the extent of the problem. Over 600 responses, 93% from private individuals, and many of them describing themselves as being in dispute. So the aim of the bill is to provide an effective means of resolving disputes over the adverse effects of a high hedge, where the issue has not been amicably resolved between neighbours. The bill acknowledges that the individuals involved should have primary responsibility for resolving disputes over high hedges. The bill defines a high hedge, and this definition largely mirrors that used elsewhere, and I am pleased that a majority of the committee has agreed with this definition in its Stage 1 report, and I will refer to the committee's report a little later. The bill gives homeowners and occupiers a right to apply to a local authority where it is considered a high hedge is adversely affecting the reasonable enjoyment of property. However, while the bill provides a mechanism for resolving disputes, it provides that pre-application requirements must be met, meaning all applicants must have taken all reasonable steps to attempt to resolve the dispute beforehand. Recourse to the local authority should be the last resort, not the first resort. And the bill empowers local authorities to make and enforce decisions in relation to high hedges. It gives them the powers to assess the situation and act as an independent and impartial adjudicator as to whether or not a high hedge is affecting reasonable enjoyment of property. We must bear in mind, however, that this means local authorities will seek to strike a balance between the competing rights of neighbours. The authority will also need to consider the effect of the hedge on the amenity area and also in relation to any cultural or historical significance. I'll give way to the
Bruce Crawford.
I thank the member very much, and I also thank him for bringing forward this bill. I think it will help a significant number of my constituents in the Stirling area. The member will be aware I wrote to him today or this week about some concerns about people had about the illegally cutting back trees and unintentionally impacting on these trees and killing them, and also issues to do with trees being too high, not being covered in your bill. I just wonder if there are any comments you'd like to make. I found your letter very helpful, I've got to say, Mr MacDonald.
I thank the member for his intervention, and I did receive the letter. He he sent to me, "It's worth stressing any decision around action to be taken will be the preserve of the local authority officer assessing the situation. There's no going to be any hedges that are too high to be included within the bill. I have included a trigger height beyond which hedges can be considered, but there is no maximum height to which the law can apply. In England, there is a notice that there is a point in the English legislation which talks about not requiring reduction below a certain height, or indeed prohibiting removal of the hedge. I've sought not to insert that because I think it's important that professional expertise is the priority, and it should be up to the individual tree officer to make the decision in that relation. And the local authority, once an assessment has been made, may issue a high hedge notice. Notice can set out what needs to be done to address the problem and prevent it from recurring. The notice can also specify a reasonable period of time within which the initial action is to be taken, and may provide a longer time for preventative action to be taken depending on the individual circumstances. Should the owner of the hedge not undertake the work specified in the notice, the Council will have the power to enter the property, undertake the work and recover the costs of that work. And an appeal process will be available to allow appeals to be made to Scottish ministers. In practice, this will be the Directorate for Planning and Environmental Appeals, which has experience of appeals similar in nature to what is proposed, and will decide on the appeals on behalf of ministers. I came to this issue with an open mind in terms of how it should be resolved. I pay tribute to the work that Fergus Ewing, as the previous Community Safety Minister, had done to bring us to this stage on the issue, and this gave me a sound basis upon which to build and take things forward. I came to the view that we needed a straightforward means of resolution, and this meant empowering local authorities to take action should the problem be particularly difficult to resolve. That is the path that has been followed elsewhere, and I investigated this option directly with local authorities in England, and the information that they gave me provided reassurance that the problems could be resolved. And I think this approach provides a degree of certainty that costs will not be excessive. It also ensures that the problem caused by the hedge itself can be tackled in a relatively straightforward way. I will indeed give way to Mr. McMillan.
Thank you very much, Mr MacDonald, for taking the intervention. So it's one of the issues that that I was the sole individual in the committee who actually didn't agree wholeheartedly with the proposed definition. So with that, that's certainly been the case, and with that kind of being the background, would you agree to accept an amendment from myself? It's based on one of the recommendations from the committee's report in terms of actually regarding the review within a 5-year period of time once the Act actually does come into force, if it's the narrow definition that's currently provided in the bill.
I thank the member for that intervention. I'm just about to talk about the committee's report, but I was absolutely happy to accept such an amendment and would have put one forward. But if Mr McMillan is minded to put one forward, I'm happy to accept such an amendment and happy to discuss with him afterwards around how that amendment could be best framed. I'm turning to the Local Government and Regeneration Committee report. I'm pleased that a majority of the committee is content with the definition of a high hedge as set out in section 1 of the bill, and even more pleased now that Mr McMillan is indicating his willingness to look at an amendment which would satisfy some of his concerns. Also, where a number of people who responded to the committee's call for evidence addressed this point, some evidence suggested it should be a broader definition, some it ought to be narrower. But I think the committee's majority conclusion is the right one. I think the bill strikes the right balance, and based on my discussions with local authorities, both in Scotland and elsewhere, this definition should mean that the costs associated with implementing the bill should not be excessive and the numbers will not be unmanageable. In its report, the committee has asked for clarification of instances where a local authority is considering an application where one or more of the properties concerned in the application for a high hedge notice are owned by the local authority. Happy to confirm that the bill requires only that a high hedge must be on land owned or occupied by someone other than the applicant for a high hedge notice. Otherwise, there are no restrictions on where the hedge is situated. The hedge could be situated on land owned by the local authority. Nothing in the bill prevents a high hedge notice being issued against a local authority, and indeed the appeal process builds in the further safeguard should there be a dissatisfaction with the outcome of any adjudication in that regard. I'm also happy to agree with the committee's recommendation that the bill should be amended to include the National Park authorities as statutory consultees. This request was made by one of the national parks and also supported by the Scottish Tree Officers Group in its written submission. And the committee also recommended a review provision, which Mr McMillan has helpfully suggested he would like to seek an amendment on in regard to, and I'm happy to take that forward. I noted the Local Government Committee's conclusions in respect to the provision at section 34 of the bill. The intention of this provision is to allow the current meaning of a high hedge contained at section 1 of the bill to be amended by making a regulation. I also noted the Subordinate Legislation Committee's different interpretation of the width of the power at section 34 of the bill. The committee expressed the view that it appears to be possible for that power to be used in future so as to significantly alter the scope of the bill. I am keen to hear the views of members on this provision in the debate, and following this will consider what action might need to be taken, including how addressing the points made by the committees might impact on the bill. I will therefore look to give this matter further consideration and contact both committees to confirm my intentions ahead of stage 2. The committee also noted concerns expressed in evidence around the provisions of the bill and how they relate to tree preservation orders. I said in my evidence that tree preservation order might be in place, but that would be dealt with through a pragmatic approach which would not be frustrated by other legislation and will ensure that protections and checks and balances for valuable trees are kept in place. I am glad that the committee is satisfied with that approach. I think this approach in terms of that aspect is very welcome. I also note the committee is content with the provisions of the bill that require local authorities to set fees at a reasonable level. The provision as drafted means that a fee fixed by the local authority must not exceed an amount which it considers represents the reasonable cost of an authority in deciding an application. And again, I think that provides the flexibility for local authorities while still allowing them to recover costs. I would like to thank Scott Hedge for their work in campaigning that has brought about this bill. I welcome the attendance of so many members, both here and also in the public gallery, for today's debate, which I think demonstrates the strength of feeling on this issue. And therefore, Presiding Officer, I am delighted to say the words that so many people have waited to hear in the Chamber of the Scottish Parliament. I move that the Parliament agrees to the general principles of the High Hedges Scotland Bill.
I now call on Kevin Stewart. Mr Stewart will be speaking on behalf of the Local Government and Regeneration Committee. Mr Stewart, you've got 7 minutes.
Thank you, Presiding Officer, and I also am glad to see you back. Presiding Officer, the High Hedges Scotland Bill came before the committee in October 2012. We received 90 submissions to the committee's call for evidence. An overwhelming majority wanted legislative action to address irresponsible actions of a very small minority. During the course of our discussions, we had 3 oral evidence sessions, and I would like to thank all of those who responded to our call for evidence, who gave oral evidence at the committee. And, it did not come as a surprise to either me or other members that there was quite a lot of heat round about this debate, because I'm sure that there's probably not a member in this chamber who has not had a case of a high hedge come to them in their constituency mailbag. Could I also take the opportunity to thank the clerks, Spice and the official report for their support and assistance. And I'd like to also put on record my thanks to all of the members of the committee who were extremely assiduous during the course of these discussions. Please note that I said assiduous and not deciduous. And I'm sorry for that very bad joke, Presiding Officer. One of the key issue was that definition of a hedge, Presiding Officer. Some wanted it to become the High Tree and Hedge Bills. Yes. Some wanted specific trees, generally native ones, native evergreens, and others such as holly, juniper and yew to be exempt. Some wanted anything that was a barrier to be included regardless of type, origin or species, and didn't see a difference between deciduous trees and evergreen or semi-evergreen hedges. We had some sympathy, but we were warned by and agreed with the majority that keeping it simple was best. We accept that care is needed to avoid an adverse impact on wildlife or biodiversity, which could have a number of unintended consequences, not least to costs and workload for local authorities. A majority of the committee support the simple definition in the bill, which follows the tried and tested approach of England and Wales. And during the course of our evidence session, we heard from the Isle of Man, where there have been some difficulties in extending out the bill to include other species and trees. And we heard about some of the costs that were associated round about that, particularly legal costs about adding that to the bill. Unfortunately, Presiding Officer, I cannot give definitive figures here because we don't have all of that. Evidence was received on the linkage with tree preservation orders. Some favoured the linking, others didn't like the connection. The committee agreed that the test local authorities had to apply was similar to the test for the making of a TPO, and therefore it made sense for the two to live together. If an authority decides that a high hedge order is appropriate and action requires to be taken against a tree which is part of a hedge, then they are implicitly determining that the continued existence of a TPO is not appropriate. There was a considerable amount of evidence on who should pay the local authorities' costs and on how much the cost could and should be. Local authorities, unusually perhaps, had little to say on this, provided the bill was cost-neutral to them. Those affected by high hedges were adamant that the hedge owner should pay all costs incurred. Such a scheme is possible, but increases complexity and also paradoxically increases costs. The owners of high hedges will, under the bill proposals, have to pay. They are liable for the cost of action that is taken to reduce the height of a hedge. The committee agreed that ultimately the intention was not for action to be required, but for parties to reach a mutually acceptable agreement. Under the provisions as proposed, there is a financial incentive on both parties to reach agreement, and the committee hope and accept many disputes will be resolved amicably. And we have some anecdotal evidence that some of these disputes have already been resolved just because this bill has been lodged by the member. Other areas that the committee considered and made recommendations about include concern that the body of expertise about trees and hedges available to local authorities is diminishing rapidly. Our suggestion to the government that they should consider establishing a central tree officer, a core of expertise available to all local authorities. We understand that such an officer already exists in Wales, and I think it would do no harm to look and see how they are getting on with the way that they have set that up, and maybe there are lessons learned for us here too. Concerns to ensure that where the local authority is a party to an application, either as applicant or landowner, that sufficiently independent and transparent arrangements are in place to ensure that justice can be seen to be done. This apparent conflict is not novel. It also occurs in, for example, planning matters and is successfully addressed there. Current review of planning guidance should take advantage of to ensure that future problems with hedges and plants are avoided. The committee visited recently Cumbernauld and saw some woodland there that the Scottish Wildlife Trust had cut back after talking to residents there. But in some regards, these disputes probably did not need to happen if they had been dealt with by the planning authority at the very outset. And I think there are lessons to be learnt there. In addition, we recommend that national park authorities be made statutory consultees in all applications for high hedge notices made within their park areas. We believe that a full review of the bill should be undertaken after it has operated for a period of not more than 5 years. This will allow a further look at the definition question and also at fees, and will present an early opportunity to amend in the light of operational experience. Our conclusions are that we support the general principles of the bill, agree the approach being taken to defining high hedges, and we've made recommendations relating to a central tree expert, reviewing planning policy in this area, including the national parks authorities as consultees, and we would like to see a reasonably early review of the operation of this legislation. Thank you, Presiding Officer.
I now call on Derek Mackay. Minister, you've got 7 minutes.
Thank you, Presiding Officer, and can I also welcome you back. I'm pleased to be participating in today's debate, reiterating the support of the Government for Mark MacDonald MSP and his High Hedges Bill. Our 2011 manifesto committed us to introduce a bill to provide a legal framework for settling disputes related to high hedges. We hopefully today will move that a step closer in terms of that commitment. I too would like to pay tribute to the work of the Local Government and Regeneration Committee, and in particular on the thoroughness of its report, being supported in its consideration by both the Subordinate Legislation Committee and the Finance Committee. I would also recognise the hard work and the efforts of all those who gave evidence to the committee over the oral sessions in December and in response to the committee's call for evidence. I know that the committee had to consider a wide range of views and talked to many experts, and not just from Scotland. There's also been discussion on the effectiveness of the legislation in England and Wales, how aspects of the recent legislation in Northern Ireland might work, as well as the slightly different legislative approach taken in the Isle of Man. We in Government recognise the need for action to be taken in this area, following our 2009 consultation, which attracted over 600 responses. This gave us an indication as to the extent of the issue. Members across the Chamber will know from their correspondence the extent of the issue and the frustration that it can cause for constituents. The responses to the committee's call for evidence, and the evidence from Scott Hedge in particular, has made clear the serious impacts that high hedges can have in the most serious cases. We also recognise that Scotland is the only part of the UK without legislation to deal with the problem of the height of a hedge. This, of course, presents us with the opportunity to learn from elsewhere. This bill learns from the experiences of others, and this is evident in the accompanying documents as well. The work undertaken by Mark MacDonald and set out in the policy memorandum shows that there can be a lot of inquiries made to councils at the outset. However, a low level of formal complaints and an even lower incidence of enforcement action necessary by a local authority tends to follow. This appears to suggest that the very presence of the legislation, as has been mentioned, encourages resolution of disputes between neighbours. This has to be the way forward, providing members of the public themselves with mechanisms to resolve disputes over high hedges. Ministers have supported this bill from the outset. Mark MacDonald MSP announced his intentions to bring forward the bill on 8 September 2011. Ministers announced their support for Mark MacDonald at the same time and have continued to support this work, both through public pronouncements, in particular the Government Memorandum on the 30th of October last year, and in provision of practical assistance. I welcome the Local Government and Regeneration Committee's Stage 1 report. It is a thorough and detailed piece of work, and it is clear that no stone has been left unturned. The oral evidence sessions, as I have already referred to, were informative and in-depth. I do not intend to go into the detail of the bill. That is for Mark MacDonald MSP to do. However, I will discuss a number of the key conclusions that the committee reached, including those which are for Government to take forward. I gave evidence on the 19th of December. I considered the definition of the bill appropriate then, and I am pleased that a majority of the committee agrees. I indicated then that I felt the definition struck the right balance and needed neither narrowing nor expanding. I am pleased also that COSLA supports the bill as currently drafted. I have also noted that the committee is content with the fee provisions as set out in the bill. The provisions as they stand allow local authorities to set a fee at a level that reflects the cost of making a decision in relation to a high hedge. This provision provides both the flexibility for local authorities to set a fee at a level that reflects their own circumstances, whilst also making sure that fees cannot be used to raise revenue. The bill also provides that local authorities can set different fee levels for different applications and can refund fees in circumstances they determine. The committee also considered the interaction of tree preservation orders with the bill. The bill takes a pragmatic approach to such orders and ensures that a high hedge notice will not be frustrated by the TPO process, while at the same time recognising the protection that such orders give to trees. I will now turn to the specific recommendations that the committee made for Government to take forward. Firstly, the committee has recommended that the Scottish Government take the opportunity of the ongoing review of Scottish planning policy to examine issues such as the proximity of residential development to woodlands. This was a point that attracted considerable discussion in the committee sessions, I understand. I am happy to say to members that I have already informed the committee that my officials will consider this as part of the ongoing review of Scottish planning policy. Secondly, the committee recommends that the Government should examine the feasibility of establishing a central tree officer to provide a core of expertise to local authorities. I am happy to confirm that my officials will discuss this with local authorities as part of their preparations for the legislation coming into force. There are, of course, a number of other conclusions and recommendations, some of which I have referred to, drawn by the committee from its detailed work, which I am sure will be discussed during the course of today's debate. I have set out what the Government intends to do in respect of the committee's recommendations in Stage 1 report to Government. I am happy to reaffirm that the Scottish Government will continue to support the bill as it goes forward. I look forward to an interesting and enthusiastic debate on the issue, and I know that many of us are keen to resolve these issues. And as has been captured in the debate already in the opening speeches, the bill is being informed and shaped as part of the ongoing dialogue, and I will commit the Government to continue to do this as the bill makes its way through progress in Parliament.
Many thanks. I now call on Sarah Boyack. 6 minutes, please.
Officer. Well, as members have already commented, this bill has been a long time coming, and I do believe in that context it's crucial we get it right. It does build on the previous work and discussions carried out by Scott Barry, a former Member of the Parliament, with his 2 goes at getting a Members' Bill through. So I very much welcome the fact that Mark MacDonald has picked up this issue for his bill. And I do also want to welcome his opening comments, because I think they've been very helpful in giving a sense of how he is going to respond to some of the recommendations from the committee. I think that's always really useful when people are going into stage 2, is that you've got some kind of sense as to what the member in charge of the bill is happy to negotiate with. And I agree with comments made already that there is experience that can be learnt from and built upon from similar legislation in the rest of the UK. I think for me the particular issue that stood out was the issue of best practice guidance, to build on that experience and ensure that this bill has a decent chance of having the positive impact that we all hope that it will do in providing a framework for resolving disputes. Crucially, it does offer the prospect of assisting both members of the public and local authorities who are charged with implementing its provisions. It's not an issue limited to any particular part of Scotland, but it is a source of conflict involving many, many members of the public. And like others, I have had some experience of this in terms of casework, although interestingly not in relation to hedges, in relation to things that I suspect would not be covered by the bill. And it is interesting to see that the very fact we're debating this bill has been enough to see some of those conflicts settled in advance of the new powers that this bill will bring. And I just wanted to reflect on that, because my experience is that where a dispute is actually established and has been going on for some time, the fact that it has been going on for some time makes it difficult to resolve. So I think anything that pushes people to really concentrate the mind and let them reflect on the fact that there will be consequences and there will be costs by not trying to resolve things amicably with their neighbours, I think that is a good thing. Many of us have that kind of direct knowledge, and I think getting a fair resolution is something that's important. So the right of appeal and clarity about how the process works is very important. So I think I'd like to start off by saying I think that the aims of the bill that we have in front of us are laudable. And I just wanted to quote, because I think actually it just goes to the heart of it, to identify a means to address the problem of disputes between neighbours where high hedges have become a point of issue and one set of neighbours form the view that the aforementioned high hedge has interfered with the reasonable enjoyment of their property. I think that's a really good summary of what's at the heart of this issue. And the test will be the detail on whether the bill gets it right thereafter through its implementation. So from the Labour Party side, we have no hesitation in signing up to the principle of the bill, along with the very, very many number of people who responded to the Scottish Government, to Mark MacDonald's consultation. But I think we do need to look at the detail, and there has been discussion already about whether the balance is right in terms of the definition in the bill. And I think at stage 2, can I encourage the committee just to spend some good time on that, because I think this is our chance to get this piece of legislation right. It's been hanging around for some time. Even if it's difficult to have the discussion, and even if people are not happy with where the committee ends up, let's have that discussion in a bit of depth. I thought the discussions that have been held thus far have been very useful. But I think the definition is absolutely crucial. And I think the Scottish Government is absolutely central to getting this right as well. So I welcome the Minister's comment that discussions will be held. I would like to encourage him. A yes on that point about the Scottish Government?
Christine Graham.
It was to do with the definition being crucial. I'm somewhat concerned that the proposal is that by secondary legislation, the definition can be changed. Do you have those concerns that may be ultra vires?
Well, that was going to be one of the last points I was going to make. That I think the committee needs to look at the comments from the Subordinate Legislation Committee very carefully, because there will be people on both sides of the argument who will want to know that the issue has been settled one way or the other. And in a way, that's why I'd like to encourage the committee really to feel free to take its time at stage 2 in this one, because I predict that we will come back, regardless of where the committee ends up, for years to come. So let's actually make the most of the chance to discuss it. And the point I was going to go on to make was I welcome the fact that the Minister is committed to having discussions about the issue of having a central officer. I would argue that in the early years, that would be fundamental to the success of this bill. And I hope that the Minister will firm up his comments by the time we reach stage 3. Because the principle of cost recovery regimes is that people agree in principle, but if the fees are really to reflect the cost of action, then I think a central resource could be cost effective for everybody, particularly where expertise can be sought by local authorities. I think that would make a lot of sense. I think that would keep costs down across the country, because as the evidence suggests, although there are tree officers and authorities to deal with TPOs, their numbers have been cut back, and they have been hard hit by staffing cutbacks over the last few years. So in terms of new expertise, new information, I think a central resource, particularly in the early years, to make sure this legislation gets off to a good start, would be money well spent. Now, I wanted to cover just briefly the issue of definition. There were witnesses concerned on both sides of this debate, and I do think, just to give you a flavour of a couple of the comments I've had, Leylandii that is too high would not be covered, as the existing Scottish law stated, that if it's damaged as a result of trimming, you may not trim. Somebody else commented that the trees the neighbour has in her garden are 50 feet tall, they wouldn't be covered in this proposed narrow bill, and there are over 17 of them. And I had another comment saying we shouldn't leave the same loophole as exists in the English High Hedges Bill. I think it's crucial that we debate this at stage 2, because there are people who are waiting in the hope that we will come down on one side or other of this argument. I do think the Legislative Sub-Leg Committee, their comments do need to be taken on board. I welcome the fact we're at stage 1, but the relationship between TPOs and SPP will be important, and I hope the debate will explore that this afternoon. Thank you, Presiding Officer.
Thank you. Now call on Margaret Mitchell, 5 minutes, please.
Thank you, Presiding Officer. I begin by congratulating Mark MacDonald for achieving the not inconsiderable feat of progressing his member's bill to stage 1 proceedings. Not only that, but doing so with the general support of the Local Government and Regeneration Committee. It certainly makes a pleasant change for the committee to be more or less of one mind on the legislation before us, given the last bill the committee dealt with was a somewhat more contentious Unoccupied Properties Scotland bill. The High Hedges issue is one which has been debated in this Parliament for nearly a decade, and as other members have stated, few MSPs will not have had the experience of constituents coming to them complaining about the height of neighbouring hedges in disputes which tend to be ongoing for a number of years, adversely affecting the health and well-being of both parties. The Scottish Conservatives have therefore campaigned for many years to change the law on high hedges in Scotland, submitting amendments as far back as the 2006 Planning Act in an attempt to introduce a similar scheme to that which exists in England. And I too remember Scott Barry made valiant attempts to get the bill on the statute book when he was an MSP. So I'm pleased the legislation is now being brought forward, which aims to provide a solution for those whose enjoyment of their property is being impeded by high hedges. This bill has the potential to establish a Scottish system to resolve disputes over high hedges, and I thank both the witnesses that sounds as though there were two, all the witnesses who submitted evidence on this important issue, and the Local Government Committee clerks for their hard work in producing the Stage 1 report. I'll restrict my opening remarks to commenting on the main provisions and objectives of the bill. It's important to state at the outset that the proposed bill is intended to be an option of last resort. Section 3 makes it clear that in order to make an application under the bill, an applicant must first have taken all reasonable steps to resolve the matter. In other words, the legislation is designed to discourage trivial claims. The bill defines a nuisance hedge as one which is formed wholly or mainly by a row of 2 or more evergreens or semi-evergreen trees or shrubs is more than 2 metres high and forms a barrier to light. This definition was thoroughly debated by the Local Government Committee, taking into account the following factors. First was the issue of single trees. A number of those who gave evidence to the committee, including Scott Hedge, expressed disappointment that the bill would not cover single trees, which represent 49% of all Scott Hedge cases. The committee decided against extending the bill in this way at this stage, having heard evidence this would not only have significant negative biodiversity implications, but could result in a flood of applications at great cost, both administratively and financially, to local authorities. Other witnesses, including Scottish Wildlife and Bell Ingram, suggested the definition could include native species, should exclude native species of evergreen and semi-evergreen plants because of their greater biodiversity value over the non-native species. However, native species can cause as much misery to the lives of homeowners as non-native species, and while biodiversity is important, it must be balanced against the other objective which the bill seeks to achieve, such as the right to light and enjoyment of property free from the distress high hedges can cause. The definition in the bill seems to strike this balance appropriately. In terms of fees, the main questions were, should there be a cap on fees and should a loser pays principle be applied? On balance, it was considered that fees should be set at an appropriate level which discourages petty complaints, but which are not so expensive as to prohibit legitimate application. This means the fee should reflect the cost of the work that the local authority has undertaken, but not be unreasonable. And whilst charging the loser owner fees could act as a deterrent, it was recognised that these owners would be making a realistic contribution to cover the costs of carrying out works. The committee considered this would be a deterrent in of itself, and that to impose an additional cost of fees would be disproportionate. In conclusion, Presiding Officer, the Scottish Conservatives welcome the legislation at stage 1, and the few areas which may need further consideration and clarification at stage 2 will be covered in my closing remarks.
Many thanks. And we now move to open debate, and I call on Graham Day to be followed by Anne McTaggart. I'd remind members these are 4-minute speeches, please.
Thank you, Presiding Officer. I've never personally been a victim of a high hedges dispute as defined by the proposed legislation. I do have sympathy, though, with the issue it's designed to tackle and those who found themselves on the wrong end of such situations, because for a number of years I had to contend with a nearly high hedge which bounded part of my own property. I say nearly high hedge because the offending structure reached a maximum height of 5 feet, and much as it annoyed me, couldn't be described as forming a barrier to light. The issue I had was more thick hedge than high hedge, and that having been planted many years earlier by a previous neighbour inadvisably close to the boundary, getting in and out of the passenger side of the vehicles parked in our driveway became a problem, owing to at times 18-inch incursion into the property. In this case, the resolution was arrived at only with the sale of the neighbouring property and the arrival of a new owner who helpfully hauled out the source of our irritation. Therefore, when I say I welcome this bill, I really do welcome it, even if it won't necessarily assist someone finding themselves in the exact position that I did. Presiding Officer, there may be some people out there, some people outside of this chamber, who might question our parliamentary priorities in introducing legislation on this subject. But I congratulate my colleague Mark MacDonald for bringing it forward, because this bill will allow people whose quality of life has been impacted upon by the selfishness of others some deserved respite. That said, I do support entirely the safeguard built into it, which requires that applicants for a high hedges notice must have taken all reasonable steps to resolve the issue before making an application to the local authority, and enables the councils to reject applications where such steps have not been taken. People who have never been involved in a high hedges type dispute may not understand how acrimonious such fallouts can be and how entrenched the positions of the warring factions can become. And we, in legislation on the matter, must recognise that whatever the rights and wrongs initially, the victims may ultimately have become almost as unreasonable in their behaviour as the high hedge owner. I accept the logic behind excluding single trees from the scope of the bill. This is a bill about high hedges, and it's right that the views of the Wildlife Trust, the RSPB and the Woodland Trust should inform the direction we take, because we must not act in a way which has the potential to compromise wildlife and biodiversity. And any deliberations on whether it would be right or not to broaden the proposed definition of a high hedge should also be informed by the view expressed by Eric Hamilton, Forestry Officer with Dundee City Council, when he stated that including any trees of any type would lead to tremendous problems. All of that said, I welcome the consensus which has developed over having a mechanism within the bill for review within 5 years in order that we can determine whether, given the experience of application, we have in fact got the legislation correct. Presiding Officer, in conclusion, I note the prediction that more than 90% of disputes will be settled without actively involving local authorities, simply because legislation exists. I would suggest it may be that moving forward we actually encounter far fewer cases of wide hedges also. It's a fact that many such situations do not have their roots in a deliberate act. People do not, by and large, plant bushes as close as they have done to boundaries or boundary fences in order to create a problem. Invariably, it will have been a thoughtless act, based only on a desire to avoid a seeming waste of garden space at the time of planting. They won't have thought 10 or 20 years hence, by when that wee bush has completely taken over a boundary, much to the upset of a neighbour. The passing of this bill will hopefully bring into focus every aspect of hedge planting and maintenance, and even help alleviate this issue that it isn't actually designed to address. For that, and all the other reasons being articulated in this debate, I would encourage colleagues to agree the general principles of the bill. Thank you.
Many thanks. I now call on Anne McTaggart to be followed by Christine Graham.
Thank you, Presiding Officer. As a member of the Local Government and Regeneration Committee, I welcome the opportunity to scrutinise the Government's proposals in the High Hedges Scotland Bill. It is clear that the bill aims to address the source of what can often be a major source of antisocial behaviour in our communities, and intends to provide individuals with a course of action to address the problem of overhanging or intrusive hedges of a neighbouring property. It is the unfortunate reality that a dispute over an overgrown hedge can quickly escalate into an issue which impacts on the quality of life for families and encourages breakdown of communities. As a result, it is in the interest of the public authorities to have the power to intervene and offer remedies in case where disputes between neighbours cannot be resolved through independent negotiation. However, we must ensure that the provisions contained within the High Hedge Bill are fit for purpose and can deliver the outcomes that organisations such as Scott Hedge have been campaigning for. Scott Hedge have campaigned to raise awareness of the problems faced by those who are victims of the nuisance of high hedges and have already identified a number of potential problems with the bill as it currently exists. Principally, the exclusion of deciduous hedges and problematic single trees means that the bill could fail to tackle instances of neighbour disputes that are prevalent across Scotland. The current definition of a row of 2 or more evergreen or semi-evergreen trees or shrubs is clearly restrictive and requires amendment if it becomes clear that too many instances of high hedge disputes are not covered by this narrow description. I believe that further analysis of this provision is necessary and that the Scottish Government can learn lessons from the Antisocial Behaviour Act of 2003, which contains statutory authority on cases of high hedges and nuisance vegetation in England. The Scottish Government should reflect on the application of the 2003 Act and perhaps seek to amend the provision of this bill in order to make the legislation as effective and comprehensive as possible. We must acknowledge that high hedges resulting in neighbour disputes is a very real and serious problem facing too many Scottish families. High hedges act not just as a barrier to light, but can restrict views, lower property values, obstruct boiler flues and block television cables. It is right that the Scottish Government is taking positive action to tackle these problems. But in order to achieve this, the legislation must also address the complex and difficult nature of the issue. We know that a number of campaigners are already concerned with the definition of high hedges is too narrow, and I anticipate that the bill, as it currently stands, would satisfy only a proportion of problem cases, failing to improve the situation of many affected by these issues. I urge the Scottish Government to reflect on the contributions from opposition parties in the Chamber and work towards a consensus in the best interest of the families and the individuals across Scotland.
Thank you very much. Now call on Christine Graham, to be followed by Colin Keir.
Thank you very much, Deputy Presiding Officer. For almost as long as I've been in the Parliament, bar a month or so, the issue of high hedges and how to cut them down to size has been an issue. So I very much welcome this movement in what my dreadful puns may very well end here, a much welcome Privet Members' Bill, bearing in mind that Privet is not apparently an offending hedging plant. More of that later. But of course it's no laughing matter and has caused much distress and dispute between neighbours and a problem for many of our constituents over the years. I think the first parliamentary question was from Maureen McMillan circa January 2000, S1W 03655, asking when there would be a consultation on high hedges. I think it was a planted question because almost immediately Jim Wallace answered that he would be issuing a consultation. 12 years later, the petition and the bill lodged first by Scott Barry, we are now getting somewhere. 12 years on, some of those hedges that may have been a problem then are certainly a bigger problem now. It's a pity, unfortunately, that no Liberal Democrats, however, are sitting taking part in what really is a cross-party debate. Why the delay? In part, it was whether to seek a solution through planning law, abatement notices, the law of nuisance, or antisocial behaviour. There was also the problem of defining what is or is not a hedge, let alone whether that hedge had to be deciduous, coniferous or mixed. That's the perennial problem with legislation. We all know a hedge, or indeed an elephant when we see one, but to define it is quite another matter. I think the definition in the bill is about as good as it can get, and to try to extend the definition to individual trees would be to redefine the whole bill from the high hedges to the High Trees and Hedges Bill. However, I note that it applies only to evergreen or semi-evergreen with live foliage. I might have thought it would, for example, include beech, which retains its foliage, though not technically live, and the ubiquitous privet. The test is that it interferes with reasonable enjoyment. I feel an amendment coming on. And while I'm on amendments, I return to section 34 of the bill, which is no small matter. To change or to extend or modify the definition of the words high hedges in a bill by subordinate legislation seems to me rather bizarre, because the whole purpose of a bill in its definition is to be secure. So I really do feel if nobody else is going to dabble in that, I may dabble. That said, I welcome the push for early resolution, which the threat of ultimate statutory intervention should assist. I agree with the proposal that a fee should be charged for an application that will certainly act as a deterrent to vexatious applications. But, on the other hand, where all reasonable steps have been taken pre-application by the party who ultimately secures resolution through enforcement, why should there not be a recovery of the fee from the offending neighbour? It may add complications, but I would like to see flexibility on recovery of the fee. There would be a further element of justice in that. The issue of existing hedges and developers, or indeed subsequent occupants seeking to have pre-existing hedges reduced or indeed removed altogether, particularly when it could be foreseen that their existence would, of course, increase over the year, should, in my view, be dealt with at the application for planning stage. And I know what the Minister said about planning law. That said, I commend Mark MacDonald and particularly all those who went before him, not the least Scott Barry, pursuing this issue, but most of all the campaigners, both Scott Hedge and others, who have been rightly determined to find a remedy for this wrong.
Thank you for that contribution from the Evergreen, Miss Graham. And now call on Colin Keir, to be followed by Helen Eadie.
Thank you, Presiding Officer. Can I welcome and thank Mark MacDonald for bringing forward this bill, and thank obviously the Local Government Regeneration Committee for their work, as well as the campaigners such as Scott Hedge. This is one of these bills that are put through, and people sort of think about it, is this really frivolous? And it certainly isn't. And in my opinion, it's one of the biggest problems, believe it or not, I used to have as a councillor
Forget about the budget negotiations going through council, anything like that. What you had was representing a ward in the city of Edinburgh that happened to be mostly low-rise homes and a lot of problems with high hedges. I did receive a telephone call one day from this very irate woman who said, "Councillor Keir, get down here very quickly, please. Otherwise, my husband may be killing the next-door neighbour." It was simply over a high hedge. It's lighting issues, it's the irritation, it's the antisocial behaviour, the whole shooting match that comes with a neighbour's dispute. And it really was, but by the time I actually got down to the place, the area that had the problem, the two men were literally fighting in the garden. And it's no joke, this is really a big thing for those who live in these areas. And there's all sorts of things that we can put the blame on, such as the planners who, in their wisdom, build houses so close together, and then we allow the planting to take place from Leyland dye, which sprouts up at a rate of knots. People think they stop at 6 feet. No, you end up with 30 feet Leyland dye. These cause major problems, and it is a very, very poor issue for those who are living next to each other, and end up in a dispute. So I really do welcome this bill as a councillor. If it goes through to its final third stage clearance, then I would imagine that for people like me who lived in that particular type of area, with a lot of houses crammed together, there will be a collective sigh of relief from many, many people. I wouldn't leave out the councillors from doing that as well. So I'm absolutely delighted. The bill actually brings forward a process, a clear process, that a dispute can be taken on after the preamble of going through the process, should I say, of talking with each other, something which neighbours once, as Sarah Boyack actually pointed out, when these disputes go on for so long, we have a situation where this is the only way that they have to sort out the dispute itself. I believe not a lot of people will want to go down this road. There are cost implications. I'm not so sure about the local councils looking to put extra officer time into this, but I think in terms of for goodwill, of course, certainly.
Mark MacDonald.
I'm grateful to Colin Keir for giving way. The evidence from down south in England was that many councils thought that they would have to appoint specific high hedge officers. What they actually discovered was that most of the work, in fact all of the work, could be encompassed within the work of those officers who already were within the local authorities. There was no need to bring in additional resource, so that might give some comfort in that respect.
Yeah, I'm glad about that, and if that's the case, I would welcome that. The local councils do have professional people who deal with these things, knowledgeable, and may be able to help people who actually live in areas such as this to at least get an idea of what sort of plants should be in the ground, what sort of shrubbery, because it is a very awkward thing. I do realise I've run out of time, Presiding Officer, but of course planners, I believe, come into play here. As mentioned by Derek Mackay, I do believe that town planners really need to take a look at these things and plan areas sensibly, and hopefully people will talk to each other and we won't need to use this legislation. Thank you.
Many thanks. I now call on Helen Eady to be followed by Stuart Stevens.
Thank you very much, Presiding Officer. And I too would like to congratulate Mark MacDonald on his success in bringing this bill to the Parliament. I think that it's something that's taken, as others have said, over a decade to get here. And I too have had a great caseload, both as a councillor previously, but also as an MSP on this issue, and that's why I have followed those who have followed this issue over the years and looked to their professionalism. And indeed, the work of Scott Barry has to be congratulated on that as well, in getting us to this point too. And I share the concerns that have been mentioned both by Sarah Boyack and by Stuart as well. I share the concerns about the definitions, and I hope that you really hear hear what these members are saying, and particularly look at the Isle of Man example as to how they managed to get round that. And whilst I talk about other countries, just mention that Denmark, France and Bulgaria are those countries that I know that already have very sound legislation in this regard. And I'm really pleased to hear what the Minister is saying in terms of the planning situation, because I think that's the heart of some of the issues that needs to be tackled as well. And I think, the fact that previously there's no final resort mechanisms have existed to secure fair and impartial exit from these often interminable and stressful disputes, as mentioned by Colin Keir a few moments ago. I think he described it absolutely spot on, and I would disagree with very little of what he had to say. The very fact that Fergus Ewing's work was done following on from the petition PE 984, which was lodged by Dr Colin Watson of Scothedge, was really something that we don't just dismiss that, because in actual fact Fergus Ewing, when he was taking this consultation forward, he talked about high hedges and other nuisance vegetation. So he didn't change the name of the bill. He talked about other nuisance vegetation. So we might well look at what Fergus Ewing was doing. He's always a great man for compromise, and so I think we should just perhaps listen to his wisdom in that regard. Flattery will get you everywhere. The consultation recognised that the problems being faced by those affected were not restricted to evergreen light blocking out, but as demonstrated in PE 984, they could be diverse in effect and produced by almost any inappropriate large plant. From reading the committee reports that Mark MacDonald agreed the Scott hedge line knowledge that a last resort intervention would cause the vast majority of submissions for help to be withdrawn without using intervention by the unreasonable party and choose to capitulate. There would be no such incentive on those whose vegetation is deciduous and excluded from this narrow bill. Widening the scope appropriately would ensure the capitulation effect would be extended to a greater number of cases without significant additional workload upon the local council staff. Yes.
Okay.
We'll all come back. I thank the member for taking the intervention. We'll all come back to the issue of definition. I just look for a bit of clarity. At committee, the Labour Party supported the current definition. I'm just wondering, has that position changed? To continue listening, has that position changed from what was agreed at committee and submitted in the report?
Helen Eadie.
Margaret Mitchell and by Sarah Boyack's contribution, the fact is that they did want to talk further about the issue and really to explore it further. And I think the very fact that your own minister saw that point as well, I think it's something that we should have regard to. And the very fact that making the bill more inclusive would send a general message that inconsiderate or vindictive deployment of all large plants was a risky and unacceptable activity. So a clear message would go out across Scotland. In Scotland, this spontaneous reaction to the anticipation of penalty has produced voluntary resolutions every time the law appeared to be imminent. There's been examples, as other members have pointed to. I don't have time to go into the detail of those, where there's already been capitulation on long-standing disputes very recently. And I think that, in evidence to the committee, Scott Hedge and Mark MacDonald, there is surely no justification to exempt deciduous or single trees from the provisions of this bill, although the choice of High Hedge Scotland Bill may present the single tree option. I just want to say that I do hope that this bill gets a fair wind. There's many points that I would like to have raised today, but I just feel that this work is vitally important, and I do agree with a colleague across the chamber who said that this is one of the things that we should deal with as priority. I think it's right that it be a priority. It's so important to many families. Thank you, Presiding Officer.
Thank you. Now calling Stuart Stevenson to be followed by Stuart McMillan.
Thank you, Presiding Officer, and my congratulations to Mark MacDonald and the progress he's made on this issue so far. Now, much of the detail of the bill and indeed the committee reports has already been covered, so I want to address one or two wider issues which relate to the subject where there may be a need for a change of behaviour as consequent upon the passage of the bill. The bill itself is relatively simple, and it's one that's informed by legislation elsewhere in these islands, of which we're part. I think the message from the evidence from the Isle of Man that the committee got tells us keep it relatively simple. Don't try and solve every possible issue that may arise with shading vegetation, because you probably actually can't do that. England tells us that behaviours start to change relatively rapidly after a short settling-in period. People stop creating monster hedges that cause disputes. Now, does that mean that naturally, not necessarily consciously, disputatious people simply find something else to argue with their neighbours about? Now, the jury doesn't seem to have much evidence to suggest that. There's certainly little evidence that the creation of a law like this before us can make things worse by creating new casus belli, new battlefronts in which antagonistic neighbours can engage. The evidence appears to lead in a different direction, a lowering of the temperature generally in neighbouring disputes. So what more can be done to capitalise on the opportunity for reasonable debate on issues between neighbours? Firstly, perhaps planners and architects, and Colin Keir in his contribution made reference to that, should have in their approach to their job a greater emphasis as they make design choices on choices that will, by design, reduce potential for tensions. For example, sightlines from windows and conservatories that little impact on what others see as their privacy. Perhaps a little less straight lines of houses, a little bit of wiggle, so that windows are less likely to look into other people's properties. Perhaps clever use of blank-facing walls close to each other, so there's genuine space on the other side of a house plot. And I'm sure there's going to be much, much more. The real point is, on the back of this, the professionals should be thinking about this. Now, very few house purchases happen without a lawyer being party to it. Perhaps lawyers should consider advising their clients. Perhaps a simple leaflet produced by the Scots Law Society might suffice on behaviours that will avoid tensions with neighbours and drawing attention to this Act. Indeed, in many housing developments, perhaps the simple inclusion in the title deeds that restricts some of the behaviours and defines how boundaries may be delineated could, in some circumstances, be helpful. There are perhaps opportunities where Council is visiting in one area where a problem... Yes, ma'am?
Christine Graham.
It's just as a piece of information that there already are conditions put into some developments called deeds of conditions that do prohibit certain kind of fencing and barriers.
I'm aware of that from personal experience, and that's precisely why I think there is a case for looking at this legislation and seeing how we can use the experience of here to help. The councils, too, when they're in areas dealing with this kind of problem, can look for potential issues, perhaps, and officials help there. On the sub-ledge issues, I think in the power to modify high hedges, it's perhaps just a simple matter of picking up what's in the ancillary condition provision of the bill, where it says, in consequence of and relating to the Act. If we put that into high hedges, I think some of the concerns of sub-ledge are likely to be addressed. Now, this issue does appear to be a largely urban issue. It seems to be one that affects areas of greater rainfall where things grow faster, but the regionality of the impact is not an excuse for inaction. I may be the only member, I cannot recall ever having had an approach, but I have a constituency with people with large plots in rural areas, quite different, but I absolutely recognise in the evidence I heard in committee that this is precisely the kind of bill we should be progressing, precisely the kind of opportunity for a member, and I very much welcome government support for this bill. I look forward to its passage in due course and happy to support it.
Many thanks. Now Colin Stewart McMillan, after which we'll move to the closing speeches.
Thank you very much, Presiding Officer. I welcome the opportunity to debate the Local Government Regeneration Stage 1 report on the High Hedges Scotland Bill. I too want to express my thanks to Mark MacDonald MSP for bringing the bill into the Parliament, and also to the Scottish Government for the extensive work it undertook prior to the bill, and also for working with Mark MacDonald to assist him in taking the bill forward. Now, when I was first elected in 2007, I knew that there was an issue of high hedges, and also I knew that there had been an issue around for some time, and also people trying to bring some type of resolution into the Parliament. Unfortunately, obviously, that legislation didn't progress, but certainly, thankfully, we're here now, and hopefully we can actually get something through the Parliament. Now, the bill that we have before us, obviously it's not come about overnight, and I welcome its introduction into the Parliament. And I know that the bill, as currently drafted, with the narrow definition of a high hedge, it won't solve every issue that confronts MSPs. But I'm also sure that if the bill were to be extended to include deciduous trees and single trees, then it too actually wouldn't solve every issue. Now, my task as an MSP who has constituents dealing with issues relating to the aforementioned categories is to ensure that any legislation that is passed through this Parliament is workable, affordable, enforceable and also easily understood. As members will know, I was the sole member who dissented on the definition to be used in the bill. Now, the definition is narrow and it focuses purely on a high hedge. Now, if the definition were to alter to include other species, it's reasonable to assume that the definition of the bill in front of us would also have to alter. Possibly the alteration of the bill would be too great and thus render the bill a vastly different document from what was actually introduced into the Parliament, as commented on from Christine Graham earlier on in her contribution. Now, as we know, the bill follows on from that already in use in England and Wales and also Northern Ireland, focusing upon the high hedge. And I've also heard regarding Isle of Man legislation, that's the Trees and High Hedges Act 2005. But also that was put in there at the outset, and that's also, so it's different, as it also encompasses trees in the title and also throughout the Act. Now, my reasoning, therefore, to dissent from the definition at stage 1 was it was really simple. I could have just accepted the narrow definition, knowing that there would be some unsatisfied constituents of mine and of all colleagues apart from Officer Stuart Stevenson, or else I could actually look to work with Mark MacDonald to try to amend the bill where possible. I don't get the impression, certainly from discussions I've had outside of the chamber with MSPs, that there's been an appetite to increase the scope of the bill. Also, throughout the committee, as I said, I was the only one who actually dissented. But I think certainly it's something that, in terms of going forward, any bill comes into the Parliament is amended in some shape or form. But I don't think that anything that's put forward in terms of the definition will actually will progress through the committee, but obviously that's entirely up to committee members to decide. Now, certainly, in terms of the bill that we've got in front of us, this certainly can be used as the platform in the future when reviewing the Act. And with that, I do want to thank Mark MacDonald for agreeing to accept an amendment from myself regarding the review of the legislation within the 5 years of commencement of the system, something we in the committee had also recommended. Now, certainly this touches upon a point from Sarah Boyack earlier on as well, regarding the importance of the definition. And that's why something the review is certainly important. Having the review written into the legislation ensures that outstanding issues will not be forgotten about and that legislation can be refined and amended as required in the future. Also, the other thing that the review achieves is something that all members know we don't always manage to achieve in this Parliament, and that is the issue of post-legislative scrutiny of legislation. We usually get caught up in issues of the day, and sometimes post-legislative scrutiny can sometimes take a back seat. Now, a final point, I'm conscious of time, signing off, so just one final point, that's regarding COSLA. I welcome COSLA's desire to work to implement the bill, and also welcome their collaborative approach thus far, and I'm sure that will certainly continue. And I'm sure that when the bill, in whichever shape or form actually does pass, that local authorities they'll be able to work well with it, and also they'll be able to work with others in due course. This also might also be an area in the future for a possible shared service once the initial glut of issues are actually raised with local authorities. And with that, Presiding Officer, I do welcome the bill coming to the Parliament. I welcome Mark MacDonald bringing it in, and also for the Government for its assistance, and also look forward to further scrutiny of the bill at stage 2. Thank you.
Thank you very much. Now move to closing speeches, and I call on Margaret Mitchell. 4 minutes, please, or thereby.
Thank you, Presiding Officer. There are a few provisions in the bill which are worthy of further consideration at stage 2. The first is about accessibility. When Mark MacDonald came to the Local Government Committee to answer questions, I raised the issue of escalating costs and the importance of robust legislation to ensure that the cost of high hedges orders does not become so prohibitive that local authorities and applicants will not use them. Ensuring access to these orders is important, and I was encouraged, Mark MacDonald stated, that he would reflect on this at stage 2. In terms of the definition, like other members in the Chamber today, the Local Government Committee had reservations about the Section 34 provision, which gives ministers the power to modify the definition of a high hedge. So it is entirely appropriate that stage 2 will provide opportunity to revisit this issue. I stated earlier that the bill creates a system of last resort, with the provision that all other reasonable options to dispute resolution must have been exhausted before application can be made. However, clarification at stage 2 of exactly what constitutes all reasonable steps would be both helpful and, I believe, strengthen the Section 34 provision's objective to discourage trivial applications. To date, constituents have also raised concerns about the possibility of a local authority having to act as a judge in a case where the local authority is one of the parties. In other words, there is a potential conflict of interest where hedges, which are subject to high hedging notices, are located on local authority-owned land. This issue was raised in committee, and the bill states that councils are to judge applications by objective standards, which seems to me a bit weak. Whilst there is certainly a right of appeal to Scottish ministers on any decision made by a local authority, and notwithstanding Mark MacDonald's comments today, I still believe that when this issue is looked at again at stage 2, perhaps the possibility of guidance being issued to councils and ministers could be considered. The tree preservation orders were also considered at length, and while I consider their role under the bill to be clear and appropriate, questions were raised as to the use of TPOs and the enforcement of them by councils, which is something I urge the Government to look at in the future. Finally, the need for collaborative working and forward planning when undertaking new developments around existing trees, hedges and woodland was also discussed in some depth. I am reassured, therefore, by the Minister's confirmation that this issue will be reviewed under the Scottish Government's review of the Scottish planning policy. In conclusion, presiding officers, high hedges may not be the most exciting of topics in politics today. However, that by no means diminishes the need for and the importance of this legislation. I therefore welcome today's debate on the proposed bill, which represents a major step forward in tackling the blight of nuisance high hedges.
Thank you very much. I now call on Sarah Boy 5 minutes, please.
Thank you very much, Presiding Officer. I think one of the reasons why we wanted to focus on the issue of definition is because once this bill is passed, it then gets enacted, and it will be with us for quite a few years. And I think what we want to do is to reflect on the comments we've received since the draft bill was published and since the Stage 1 committee discussions and since the committee's report was actually published, because we don't have a revising chamber. So I think the comments that were made by Stuart McMillan about the need for review are absolutely spot on. We need to have review of this legislation, but we need to set the parameters of why we think the legislation particularly will need to be reviewed at the start. And I think that is acknowledging the fact that not everybody agrees on the definition. So I think up front we need to have that discussion so that we're clear that we're not just monitoring it for the sake of it, but wherever the committee comes down in detail, and that will be hugely significant for the rest of us in the Stage 3 debate, we do want you to scope for us what the issues are that you think are either outstanding or issues that merit further consideration and monitoring. And I think that's equally important to local authorities and Scottish Government, who would be the key players in terms of monitoring the legislation as it goes forward. And I certainly was very struck by the committee's recommendations when Mark MacDonald was quoted about the potential to change the legislation in the future, where he did give a view about potential things that could change and the difficulty of giving a yes or no answer to the role of a statutory instrument. I do think it is worth us collectively bottoming out some of these issues so that when we go back to our constituents, when Scott Hedge come and lobby us again, we've actually got some clear answers, and the decisions about the definition are taken in the light of not just the first set of recommendations made to people, but consideration of them afterwards. And I think that is one of the things that the early consultation gives this Parliament the capacity to do. But once we're into stage 2, stage 3, it is quite a fast process. So that's really, to answer the Minister's point directly, we haven't come to the point of having supported it in the committee, we're now against it. It's not that. It's more about teasing this out. Yes, I'll take the convener.
Kevin Stewart.
Officer, and I thank Ms Boyack for taking the intervention. I think one of the key things here is about getting this legislation absolutely right. And in terms of expanding the definition, I think that members need to look at some of the evidence that was given by the Isle of Man, who have expanded this out a lot further, but obviously have come across a number of difficulties, least of which is cost. And I think that we could get ourselves in a real pickle if we, at the beginning, over-egg the pudding here. And, you know, I think that the review that the committee was unanimous on is the right way to do this. Let's get it right to start with, within broad definitions, and see what can happen after that.
Thanks for that lengthy intervention. I think I understand that, and as you've convened this committee, you will know the range of different views. It's not that we're saying that you haven't done your job or anything. It's more just wanting to test this out. I think the comments that Christine Graham made in terms of the past experience many members have had in this chamber, this is the time to test it out. We don't get to play around with it at stage 3. Once the committee is basically given the framework at stage 2, it's really unlikely we're going to come back and change things dramatically at stage 3. I think we all accept that. I do want to reflect on the relationship between the legislation, between the tree preservation order regime and between the planning process, because I think those issues are crucial as well. Much of what drives this is people's right to privacy and people's right to a living environment that they value and reward. And I think there are lessons for the planning of developments, thinking through what a development is going to look like in 20, 30, 40 years' time, which most people don't think of. People are thinking about where the grass is, what kind of plants are there initially. But the issue of landscaping, trees and hedges is fundamental, and hopefully the discussion we are having can be fed back to further up in the planning process, not just to planners but developers as well. Those things are actually crucial in terms of our built environment. And it does link into biodiversity, because when we have a new development beside an existing woodland, that's a use that's really important, because the woodland is providing a backdrop and a quality to that housing, but it's got to be a compatible backdrop. And I think what this legislation highlights is the need for a bit of joined-up thinking early doors when developments are being planned, because it's the residents 30, 40 years later who live with those calculations, who live with the decisions of the planning committee or the planners or the developers. So I think in that sense, that again is why the definition is quite important, because what we put in this legislation in a few weeks' time will shape these debates for years to come as well. And it's taken us so long to get to this stage. Let's make sure that we do test this out to the best of our ability at stage 2, so that when we come to stage 3, the amendments we've got are easy to deal with and are not fundamental to the bill. Let's test it out at stage 2. Thank you very much.
Thank you very much. Now call on Minister Derek Mackay. 6 minutes, please.
Thank you very much, Presiding Officer. I think it's can I thank Sarah Boyack for those helpful comments in terms of the position of the Labour Party, because I was a bit unclear of where it was going. I think it just goes to show that this is a members' bill, and members within political parties can take different views. Disagreement, diversity of opinion, dissent, and that's just the SNP group in terms of how you take this forward, which shows a listening group, a listening government and a listening parliament will help shape this bill going forward. I know that the planning system's made it when it both features in this debate and also has its own TV programme now on a Thursday night, The Planner, reality TV for the planning system, and I'm waiting for the first single tree or high hedge to feature in that particular debate. but no, it's in the evening, Ms Graham. Can I say that this is a very significant issue, and if the Parliament wasn't legislating on it, I think people would quite rightly ask us why, because we are, as I've said, the only part of the United Kingdom where there is no legislation covering this issue. So, as many members have said, it's very appropriate that we debate this and get the legislation right at the outset. But I do want to focus on the issue of definition and the options open to Parliament. Government's taken quite a relaxed view on this. We've given evidence, we've given a position, but we've said we'll listen to Parliament and to committees as to what Parliament thinks is the appropriate way forward. Options now on the table through the course of the debate could be the review process, a sunset clause where we revisit it, and I would suggest and encourage that we're as flexible as possible, if that is taken us forward, to look potentially at issues of definition and other matters, and that would be a question for Parliament to return to if it's the review process that's considered or the secondary legislation. And of course you would say, well, I would want that, wouldn't I, as a government minister, that we have the ability to amend the legislation. The reason I think that that could be helpful is that that would give us the ability to change the definition in light of circumstances. But it's for Parliament to choose which option it prefers, whether it's to expedite this through secondary legislation or it prefers the review process, which potentially would return to primary legislation, of course.
Sarah Byatt.
I think what I'm trying to tease out is it's not just the process by which you carry out that future review, but in Mark MacDonald's own comments, he did say the definition could be amended to include, for example, deciduous hedgerows as opposed to evergreens or semi-evergreens. Other people have mentioned trees. Isn't it important that we just narrow down why some things are being suggested for inclusion and why others are explicitly excluded? And then you get to the process of what is the best way to amend this in the future.
Minister.
I think that's a fair point. What I'm trying to tease out is how much flexibility would Parliament want to give to reconsider this at some point in the future if it thinks that the current definition might require to be revisited. It might be the case, of course.
Christine Graham.
It's following the same point. If you start out with a definition in which some people are committing an offence, let's call it, and later on you change that definition to extend it or narrow it, then if you extend it, you're saying that people are now causing offence that didn't exist previously under the same legislation. It's not. People must be secure in the knowledge that what the definition says is what the definition does, and it won't change.
Minister.
Circumstances might change in the light of how the legislation beds in, what the public make of it, and then how Parliament and Government and local authorities can respond. What this debate is about is how much flexibility you would want to give that. Now, Government doesn't have a strong view whether you choose the review process or secondary legislation. As I say, we're quite flexible and open-minded in how that's taken forward. But in terms of the legislation and the definition right now, I think we should look very closely at the evidence we've received as to what happens in each part of England and in Northern Ireland, which is relatively new, and of course, and the Isle that was referred to earlier. But for me, if we were to substantially change the definition at this point, I would want to return to local government and consult them on any changed definition, because they will be executing this in practice. And they, of course, are working on the assumption that it's the current definition as outlined in the bill. A number of other matters have been raised, touching on the government's involvement with Scottish planning policy. I should say that's particularly around the recommendation that the committee made as the proximity of development to woodlands. That's specifically what we were asked to consider, as well as that central resource around expertise, which we're happy to explore with local authorities as well, but it does seem like a very sensible suggestion. I'm not quite sure how to encapsulate Stuart Stevenson's little bit of wiggle in the planning system, but certainly we can try and express that through our planning advice notes and other places. Colin Keir very helpfully suggested that this is not a frivolous matter, but very serious. In terms of Anne McTaggart focusing on the definition, and again, like many other members, focus on how it might get better behaviour from residents in the first instance, and Graham Day explained why his issues are not necessarily of height, but of width, and just hopefully this will create the right attitude in terms of being a reasonable and responsible neighbour following the provisions within. We've not spent much time focusing on appeals. Maybe that will feature in stage 2 and in stage 3 in terms of the debate and how that's taken forward by the DPEA, but I am satisfied that they have the capacity to deal with this. And fees, a very important point, that this is not about income generation by local authorities, but early resolution of these matters of antisocial behaviour, and a soft cap on fees, that they can't generate more income through this. It is about the cost of taking the necessary action. So I hope, like every other member in the Chamber, on a cross-party basis, we can continue to explore this, get the definition right, and ensure that it has the intended impact that we all seek, and Government will continue to take a constructive and positive approach in this bill process.
Many thanks. And now call on Mark MacDonald to wind up the debate. 8 minutes, please, Mr MacDonald.
Thank you, Presiding Officer. Can I say at the beginning, this has, I think, been a fairly constructive debate. Certainly, I have found myself cringing at the number of hedge puns that have come forward. Who knew that we had so many comedians in the chamber? But can I say, we heard evidence from Colin Keir and Helen Needy of their time as local councillors, and the issue being prevalent then. That was one of the motivations that led me to pursue this, was having been a local councillor and having felt that frustration of there not being a point of last resort for many of these disputes. So let's look at some of the issues that have been raised in the debate. I think the first one that we should spend a bit of time on is the definition. And there was a discussion around why have you not widened the definition to look at other areas. And I think Kevin Stewart and Stuart Stevenson very helpfully referred to the experience in the Isle of Man. Not an entirely analogous system, because they've pursued it in a different way, but it does give us cause to look at how their experience has been and the complexity that is often involved in terms of the assessments that are required for deciduous vegetation. We're talking about a 12-month round inspection process in order to establish the impact of a particular tree or a group of trees. You then build in that as a cost factor, which would then be potentially recoverable by the local authority, and you're looking at a potential substantial fee being attached. Now, my view would be that we need to take time to bed in the legislation before we look at the possibility of a widening out and looking at that, and looking at how the fee system works in practice, because I'll come on to that later on. But in terms of the review, and I'm grateful for the comments from Stuart McMillan and his willingness to look at a review mechanism within the legislation, and I think that's entirely sensible for the reason I've outlined there. But it's not just the definition that you would look at reviewing as part of that. Yes, the definition is something that we spent a bit of time talking about today, but there are other aspects, for example, around the fee system, around the appeals process, and other aspects of the legislation which would be worthy of looking at to ensure that they are working in a way that we envisage. In terms of Christine Graham's point, I mean, my understanding is that privet would be captured by this legislation by notion of it being either evergreen or semi-evergreen, depending on where it is. But happy to look into that further on her behalf. Well, around beach, I think there are characteristic elements of beach which I think led me to feel that it was not should not be included within the legislation. But again, happy to reflect on that and talk to the member, and perhaps write to the member after the debate with a little bit more detail around that. I was concerned at points, listening to some of the comments from Anne McTaggart and Helen Needy, that the position that Labour had taken at the committee in terms of backing the definition seemed to be changing substantially during the course of the debate. And I would simply say to them that I think I've outlined my views around why I've drafted the definition the way I have. I'll listen to the points that are made by other members, but they must accept that a change to the definition has a knock-on effect to other aspects of the bill. It cannot simply be viewed in isolation, and the fee element, which I'm about to come on to, is a big part of that. Now, we'll take an intervention from Margaret Mitchell.
The comments from the members you mentioned was to reflect that the report said the definition at this stage we were content with, leaving it open to look again at stage 2.
I will take that point, but that leads me on to the point around the fees issue. I think the Minister was quite right when he said that the point around the fees is that this is not intended to be a revenue-raising mechanism for local authorities. Indeed, the evidence from south of the border is that it would be particularly foolish for any local authority to assume that they could use it as a revenue-raising mechanism, because the experience from south of the border is that an initial flurry of inquiries leads to a much, much smaller number of formal applications, which then leads to an even smaller, in fact a minuscule number of times where the local authority itself requires to take action, which I think bears out the comments that were being made by the likes of Graham Day and Colin Keir about this being very much people will it will regulate people's behaviour simply through its existence as a form of legislation, and where requirement is there for an assessment and then an enforcement notice from the a remedial notice from the authority, people will take that seriously and they will take that action and will not seek to frustrate that. So I think that bears out. I've made it very clear that I believe it's for local authorities themselves to determine their fees and what fees they apply. The requirement in the legislation is simply that it allows the local authorities the ability to recover their costs. Now, it may be that some local authorities would choose not to do that, would choose to structure their fees differently depending on income, depending on other aspects. It will be for local authorities to determine that. But there's another regulatory mechanism built into that, which is, of course, in my time as a local councillor, if I had constituents beating down my door saying that they couldn't afford to access a particular service of the council, it would lead me as a local councillor to ask questions of the authority. So there is that element to it as well, that I think that council committees and local councillors will ensure that a fee system that is put in place is one which does not prohibit their constituents from accessing the process. In terms of the fee transfer argument, and I heard the comments from Christine Graham, and also Margaret Mitchell and her colleague Gavin Brown pursued this with me at both the Local Government and Finance Committees. I think that in the Northern Irish example, we've looked at the Northern Irish example, it's still very much in its infancy and there's not a lot of data there to establish the success or otherwise of the scheme. I still retain the concern that, that there is a risk around a fee transfer mechanism, that you run the risk of creating or adding to a dispute whereby if a neighbour receives a remedial notice, complies with that remedial notice in full respect of it, and is then asked to pay a surcharge to cover the fee that their neighbour had paid, I think that runs a potential risk of animosity being created. But again, I had said I would look at that. If members are wanting to bring forward amendments on that, I'll look at them and consider them. But at the moment, I remain unconvinced around the prospect of a fee transfer system being put in. I'll take a brief intervention.
Christine Graham.
Just simply to put the point that if you were acting and warning somebody in a legal letter, you would say, that if you do not comply with this, you may be liable for the fee costs. And I think that that's another thing that would be put in at the beginning, the sword of Damocles. Not only are you going to be charged for the cutting down of the hedge and reducing its height, you may be liable for the fee costs as well. I don't see why there's a problem there.
Mr MacDonald, I'll give you a little extra time to compensate for the interventions you've taken.
I'm very grateful for that, Presiding Officer. I take on board the point Christine Graham mentions. However, my earlier remarks in relation to how the cases break down south of the border imply that local authorities never, I think there's one example that we managed to find where a local authority had to go in and do the work and recover the cost itself, which would then, in the example that Christine Graham mentions, have kicked in a fee transfer system. In terms of the subordinate legislation recommendations, I take on board the points being made by Sarah Boyack, Christine Graham and Stuart Stevenson, who I think made a very helpful and constructive suggestion as part of his speech. I've said already that I will take a further look at that, particularly in light of the issue around a review clause, and look at how those two particular elements of the bill will interact with each other, and I'm happy to reflect on that. And one final thing, Presiding Officer, if I may, a couple of myths that need to be busted. There's no such thing as a too-tall hedge under this legislation. So anybody who is making the remark that a hedge would be too tall to be tackled as a result of this legislation has got the wrong end of the stick. There is a 2-metre trigger height, at which point any dispute can be considered. Beyond that, I've made no stipulations. And in terms of the point that my colleague Bruce Crawford made in his intervention around the notion that down south there is a provision within it that you can only trim to a certain height, or that you cannot take action which might lead to the removal or the destruction of a hedge. My view is that I want to leave it to the expertise of the professionals. If the only way to deal with an issue is to remove the hedge, that should be an option that is open to the individual tree officer who takes the assessment to recommend. With that, Presiding Officer, I do think it's been a constructive debate. I've got much to reflect on going forward to stage 2, and I'm sure members will be more than happy to have their input as part of that process, and I look forward to the debate continuing.
Many thanks. And that concludes the debate on stage 1 of the High Hedges Scotland Bill, and it's now time to move on to the next item of business, which is a debate on motion number 5556 in the name of Rosanna Cunningham on promoting and protecting human rights, Scotland, Europe and the wider world. I'd invite members who wish to speak in the debate to press the request to speak buttons now or as soon as possible, and if we're all sitting comfortably, then if you are ready, Ms Cunningham, we have 10 minutes for you to speak to and move the motion, please.
Thank you, Presiding Officer. I want to open this debate by talking about values, about the principles which lie at the heart of this Parliament, about Scotland's deep-rooted attachment to concepts of fairness and justice and equality, and about the ideals which unite us all across this chamber without regard to party allegiance or political difference. These values are reflected in the Scotland Act, which embedded human rights into the practice and purpose of Parliament and of government. And they're part of a shared commitment to improvement, to doing better, to making a difference to the everyday lives of real people. So this debate celebrates both our own efforts in Scotland to make rights real for ordinary people and the existence of an overarching international framework of human rights law which helps safeguard the vulnerable and the oppressed throughout the world. It recognises, too, the need for us to recommit ourselves to making a difference, to the lived lives of people in Scotland, and through the role that Scotland can play internationally, both now and in the future, in helping to ensuring that rights are protected, respected and promoted. Why are they important? Well, as Eleanor Roosevelt, the driving force behind the 1948 Universal Declaration of Human Rights, said, "Where, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any map of the world. Yet they are the world of the individual person, the neighbourhood he lives in the school and college he attends, the factory, farm or office where he works. Unless these rights have meaning there, they have little meaning anywhere." Of course.
Neil Findlay.
Thanks very much. You mentioned the workplace. Over the last few months, we've seen exposed the human rights abuse of workers who have been blacklisted, and that is a scandal that is still occurring or may still be occurring in Scotland. Would you support this Parliament having an inquiry into that issue?
Minister.
I think that there are inquiries into this taking part right now, and I know the Minister has, the member has a great deal of interest in this, but I'm trying to take this debate onto an overarching level and a discussion of wider values. And I'm not entirely clear why the Labour front bench seems to think that's so funny, but nevertheless we will attempt to keep the tone elevated. So human rights are not just principles on a page, nor are they a charter for criminals, as has often been said. They are a concept and a reality that is of fundamental importance to us all. So as a government, we do work on a daily basis to progressively realise the fundamental rights of the people of Scotland. So reforms to policing, the criminal justice system and the health and social care sectors have human rights at their heart. Legislation on the rights of children and young people, of victims and witnesses will be introduced this year. And can I take a moment to address the Labour Party's amendment to today's debate? Members will be aware that we do take human trafficking very seriously. Our aim is to make Scotland a hostile place for traffickers. We are demonstrating leadership on this issue and progressing actions agreed at the high-level summit chaired by the Cabinet Secretary for Justice in October last year. We've already made clear that we will bring forward a specific human trafficking statutory aggravation to ensure that where trafficking forms the background to an offence, that can be taken into account by the court. And second, the summit agreed that there was a need to review the wider legislative framework for trafficking and identify any potential improvements to be made or gaps to be filled. And that work is now progressing with key partners who met this morning. The group will report back in the middle of this year, so in a sense we're already doing what Labour wants us to do, so we have no problem with accepting the amendment. It is within the wider perspective that we should be looking to address the wide-ranging challenges inherent in giving full effect to the rights of all. The Scottish Government is certainly of the view that everyone in Scotland should be able to access their rights. Indeed, if there is a theme that distinguishes this Government, it is a belief that individuals, communities and indeed nations have a fundamental right to make decisions for themselves, to take responsibility, to exercise capacity and to direct their own affairs. When Scotland votes in 2014, there will be, I hope, opportunities to take what we've already achieved to a new level, with new powers and a heightened sense of ambition. As the First Minister noted in London recently, the time is ripe for a debate on how Scotland both guarantees and implements rights, and how we ensure that constitutional guarantees place the person at the centre of the system, rather than at the bottom or the margins. And this includes the economic, social and cultural rights already reflected in the constitutions of many other democratic modern nations. And with that in mind, I warmly welcome the initiative by Scotland's National Human Rights Institution, the Scottish Human Rights Commission, to facilitate the development of Scotland's first National Action Plan on human rights. The United Nations describes this approach as an international example of best practice in ensuring that the human rights within a jurisdiction are assured and not assumed. Other progressive jurisdictions have such plans, for example Sweden and New Zealand, and I welcome the fact that Scotland is joining them. The Scottish Government is certainly committed to playing its part in the development of a plan with realistic actions and measurable outcomes. And the direction of travel is promising. We are delivering a step change in public service delivery and an increasingly focused approach to tackling inequality. I hope to see a plan that goes with the grain of these developments, and I feel it's particularly important to rebut any suggestion that this will somehow be a plan for the Scottish Government alone to deliver on. I see it as an exercise in co-production, cooperation and empowerment. Its ultimate success will be founded on a principle of shared ownership across this chamber, the wider public sector and the whole of Scottish society. It will be Scotland's plan. So 2013 is an important year for human rights in Scotland. The debate around human rights can arouse strong passions and strongly polarised opinions. And I do find it a bit worrying that parts of the UK Government are demanding the scaling back and, in some cases, wholesale removal of the domestic framework of human rights in the UK. The discourse of some within London is coloured by what seems to me a certain parochialism and a perception of human rights as an inconvenient barrier. The Westminster debate is sadly out of touch with the needs of real people, but in Scotland, human rights are a positive thing. They're part of the very fabric of our society, which celebrates community and belonging, but also looks outwards to what the international community can teach us and how we might better ourselves as a nation. So, Presiding Officer, in bringing this debate to the Parliament, what we wish to achieve is... Yes, of course.
Fraser.
The impression the Minister is coming towards the end of her remarks and she has not said much yet about the international situation. Can she say something about the role the First Minister has taken in promoting human rights internationally? For example, when he makes visits to places like Qatar, whose human rights record is somewhat dubious.
Minister? The greatest of respects, I think that question would come better from somebody who's not in a party, whose government is busily in other parts of the world doing things which anybody might suggest are themselves transgressions of human rights. And the member may have noticed the Minister for External Affairs here in the Chamber, and that is because we are going to be addressing that. I've addressed myself in particular to the SHRC National Plan for human rights, because that is the trigger for this debate. That's what I want everybody in this chamber to consider. But equally, we do want to have a conversation about international human rights, and my colleague Hamza Yousaf will be addressing that issue directly. But can I ask members to take some care not to express themselves with a degree of hypocrisy here, because with the very greatest of respects, I haven't noticed any activity on Westminster governments of either party in this chamber who are behaving in a way that I think any of us here might consider to be appropriate, not least of which the promulgation of what, frankly, wasn't much more than an illegal war. And I listen to what's here, but while we are talking about human rights internationally, let's talk about all human rights internationally. And that includes the human rights of people who have been violated over many years by both Westminster governments. And I'm kind of sorry that we've gotten into that. Well, no, I'm actually now in the last 20 seconds of the 10 minutes that I've been allocated. And what I want to do is to talk about the situation in Scotland in 2013. I do invite members to support the motion. I want them to reaffirm the commitment of the Scottish Parliament to the vision of an inclusive Scotland and a more equitable world in which human rights and fundamental freedoms are truly central to the lives of all.
Many thanks. Did you move your motion?
Oh, sorry, did I not do that?
I don't believe you did.
Move the motion.
Thank you very much. I now call on Jenny Mara to speak to and move Amendment 5556.2.
Thank you,
Ms Mara, you have 7 minutes.
Thank you, Presiding Officer. I was sincerely hoping that the Minister may set the tone for this debate, as a serious debate it is, and talk about the reality of human rights in people's lives in Scotland. But I would thank the Government anyway for bringing this important issue of human rights to the Chamber today. I feel the Labour Party has a strong record of promoting human rights. Clement Attlee's government was one of the first signatories to the 1948 UN Declaration on Human Rights and ratified the European Convention in 1951. As one of the first actions of the Labour government in 1997, we incorporated the European Convention on Human Rights into UK law, and every act in this Parliament has to be compliant or it is nullified as a result. And since the Human Rights Act 1998, citizens the length and breadth of this country and across the United Kingdom have enjoyed the protection of the Convention. The Human Rights Act, of course, is still in its formative years. It takes shape in our courts every day, resulting in some of the biggest changes to our law in recent times. CADR, for instance, the right to legal representation for people being held for questioning in Scotland. But the important task, Labour believes, is to get on with that job of making human rights and the fact that they're daily afforded to people a reality in their lives. Protecting the rights of those affected each day, every day at the moment by welfare reform, and of vulnerable children in this country. We need to weave human rights into the fabric of our communities through the laws we pass and the policies we advance in this chamber now, using the immense powers that we have today. Our motion, and I thank the Government for indicating its support for our amendment today, advances that cause specifically. Human trafficking is a human rights abuse that is happening in our towns and cities today, under our noses, but unfortunately largely undetected. And we have the power here in Parliament today to take concerted action against this trafficking. The victims of trafficking in Scotland today cannot wait for a written constitution enshrining their rights, nor do they even need to, because the government in power in Scotland, sitting over here, has the power it needs to make a big impact on this human rights abuse now and today. If I were to stop any Scot on the street outside this Parliament building and ask if they believe that people have been sold into this country, living in their town, against their will, working in the sex industry and forced labour, people would most likely not believe me. It is very hard to accept that this is alive in our communities today, and they would be shocked further, Presiding Officer, if I were to tell them that there are young people incarcerated in our prisons tonight, convicted of drug offences, who we believe were trafficked into this country to work in drug farms. Young people incarcerated in Scotland who have been convicted of crimes as a result of coercion and deception of others. These are the human rights abuses, Minister, that are taking place in Scotland today under our very noses, and they are sitting in our prisons tonight. Yes, certainly.
I just wonder if the member is going to mention at all the role the United Kingdom Borders Agency has in all of this, or whether she's going to simply ignore that aspect of things.
My co-convener of the Human Rights Cross-Party Group will know that this is a multifaceted problem, and the UKBA is part of this. But the point that I'm trying to make in my opening speech is that this Parliament has a great lot of powers that we can use to properly tackle and prevent the issue of trafficking. And I'm very glad for that reason that the Government has decided to accept our amendment, but I want to talk a bit more about the powers that we do have to tackle human rights abuses in our communities today, because I'm sure the Minister would agree with me that she would want to use all the powers at her fingertips to do as much as she can to prevent these human rights abuses, because these... Certainly.
I wonder if you could name one single solitary person who has not, who you know, has escaped due process with regards to trafficking. One.
Jenny Mara.
I'm not exactly sure the question that the member is putting to me, but if I do understand, I'll attempt to understand that there are many people we believe are trafficking people into this country today that go undetected because the police and other frontline services are not properly trained and do not have the tools to recognise them. To date in Scotland, there have been 2 successful prosecutions and 5 convictions of trafficking offences, but it is much more widely spread than this. And so that due process has to be visited on many people that are trafficking people into this country today. I hope I have answered the member's questions. But these priorities are ours to decide. And we know the flaws in our current approach to trafficking. It lacks well direction and, as a consequence of our laws and policies, has developed in a piecemeal fashion, and victims are slipping through the net. Because our law is currently split between 2 acts, one UK Act of Parliament and one Act in Scotland. This gives a different definition to the same crime. There is no statutory obligation to provide comprehensive mental health treatment and education services to victims, and we lack training for NHS staff, paramedics and police officers who could do so much to identify victims and give them the support that they need. The Labour Party supports incorporating the Palermo Protocol into our law, and I wonder if the Minister, as she's accepted our amendment today, would go a little further and perhaps speak in closing to the possibility of incorporating the international gold standard, which is the Palermo Protocol on trafficking. I realise I'm drawing short of time, Presiding Officer, but I believe we have the power here in this Parliament today, through control of housing, education, health and legal affairs, to put these measures in place. Experts like Helena Kennedy have set out recommendations within the power of this Parliament, and I believe that the Government could make a big move today towards ending human rights abuses in Scotland by supporting our amendment, as you have done, and committing to the Palermo Protocol to prevent trafficking and human rights abuses in Scotland.
If you too would like to move your amendment, that would be helpful.
And I move the amendment in my name.
Many thanks. And I now call on Annabel Goldie. 5 minutes, please.
Thank you, Deputy Presiding Officer. Can I too welcome the opportunity this afternoon to speak on this important topic, and particularly Scotland's responsibility to protect the rights of its own citizens and promote a similar approach abroad. I think there is certainly a strong element of consensus on this topic across the Chamber, and despite the natural reservations of the Minister, I think that also extends across the United Kingdom, because all major political parties are signed up to the importance of human rights. But where I think the scope for debate is the best way to enforce and interpret these rights, a point that I will return to later. Equally importantly, I think the framework of human rights must enjoy the support and confidence of the public. That positive perception is essential, and a negative perception is deeply damaging. What the public may support in theory, which is good, does not necessarily translate into support in practice, and that's bad. So let me develop that theme. Now, Now, I do agree with the general tenor of the motion, which my party will support, and I welcome the opportunity for this Parliament to reaffirm its commitment to human rights, and I also support Jenny Mara's amendment. When I was reading the motion, I did reflect on the use of the term inalienable. Deputy Presiding Officer, every member in this chamber has signed up to human rights as a set of fundamental rights which every person can expect to enjoy. Nevertheless, all rights are subject to interpretation, and crucially, all rights do interact with each other. And I think it is legitimate to explore that aspect. So I do pose the question, and I pose it genuinely. How do we reconcile the absolute right of, say, a victim with the absolute right of an assailant? These opposing rights, the right to a fair trial and the right to liberty, of one is balanced by the right to security of person or the freedom from ill treatment of the other. And in this case, granting absolute or inalienable rights to these two individuals seems to me potentially irreconcilable. The use of the term inalienable, you could have picked an easier word for the motion, Minister. The use of the term inalienable therefore ignores the fact that fundamental rights can actually sometimes be in conflict and not recognise that with rights also comes responsibility. Well, I'm very tight for time, and I'm sorry. I do want to develop this point, and I hope the member will forgive me. Interestingly, the European Convention on Human Rights actually does recognise that potential, and very few of its articles are absolute rights. They actually are all qualified by consideration of the greater good. Now, Deputy Presiding Officer, it is no secret that the general public's opinion of human rights is not as positive as it could or should be, and certainly as we would want it to be. A YouGov poll published last year found 72% of the public thought human rights have become a charter for criminals and the undeserving. And a similar poll published a year before found 75% of respondents believed the Human Rights Act was used too widely to create rights it was never intended to protect. And I think, Deputy Presiding Officer, that isn't something we should either ignore or just brush aside, because it is actually in the interests of those of us who champion fundamental human rights to bring the public on side and improve that perception. As I said earlier, a negative perception by the public is deeply damaging. And I do think it's right that the UK Government considers reform to the human rights regime. And may I say, for the benefit of the Minister, it is absolutely not the case that the UK Government wants to repeal the Human Rights Act. It is looking at replacing it with a new Bill of Rights. And I have to say that I think 15 years on from the Human Rights Act, it is appropriate to consider whether reform could strengthen the regime. And perhaps we do need to look at, is there a requirement for a shift in emphasis to achieve this balance, to get rid of this irreconcilable element, to look at those who do wrong and compare that with the rights of the victims. Deputy Presiding Officer, it is a paradox, I think, that lawbreakers can demand as of right a voice in lawmaking when they showed scant regard for upholding the law in the first place. And I think this illustrates a dilemma, and I think it illustrates one of the reasons why, sadly, the public has apparently a poor impression of the human rights framework. But I think by considering reform, we do have the opportunity to strengthen it and to win over the public, both of which, in my opinion, are good for human rights and Scotland. Deputy Presiding Officer, as I move to close, I hope I can adopt a more consensual note. I know that everyone in this chamber remains absolutely committed to the importance of human rights in Scotland, in the United Kingdom and worldwide. And a modern democratic Scotland, as part of the United Kingdom, has a responsibility to promote good practice abroad. Now, closer to home, I note with interest the work of the Scottish Human Rights Commission on developing Scotland's first National Action Plan for Human Rights this year. Action plans, I understand, have already been drafted in around 30 countries across the world, and I am sure in Scotland it will represent a significant step towards informing and educating about human rights, as well as identifying any gaps in good practice. And I certainly wish the drafters of that action plan every success.
Please.
In conclusion, Deputy Presiding Officer, my party will support the motion.
Many thanks. And we now move to open debate, and I call on Christina McKelvey to be followed by Graham Pearson. 4-minute speeches, please.
Thank you very much, Deputy Presiding Officer. I warmly welcome the Scottish Government's positive and progressive work towards Scotland's National Action Plan for Human Rights. The Action Plan is a key recommendation from the UN and is championed by the Scottish Human Rights Commission. Human rights are commonly understood as inalienable fundamental rights to which a person is inherently entitled to simply because she or he is a human being. Human rights are thus conceived as universal, applicable everywhere, and egalitarian, the same for everyone. These rights may exist as natural rights or as legal rights in both national and international law. The doctrine of human rights and international practice within international law, global and regional institutions, in the policies of states and in the activities of non-government organisations has been a cornerstone of public policy around the world. Promoting and respecting is a very important aspect to a rights-based nation and a rights-based constitution. I hope my friend and colleague, the Minister, will agree with me that the onus is on government also to fulfil and on Parliament to oversee and ensure that fulfilment of the human rights-based society. The requirement is for states to ensure, protect and fulfil the human rights contained in the treaties they have ratified. That raises the question of what needs fulfilling and how could we achieve that. The International Covenant on Economic, Social and Cultural Rights is one aspect for consideration. These rights include an adequate standard of living and the continuous improvement of living conditions in Article 11.1, the enjoyment of the highest attainable standard of physical and mental health in Article 12.1, the right of everyone to take part in cultural life, 15.1, to work and free choice of employment in 6.1, and the right to social security in Article 9. Is it possible that the Scottish Government Parliament could be called upon, Deputy Presiding Officer, to inform people of their human rights under international law, including economic, social and cultural rights, formally and publicly recognise poverty as a violation of human rights, step up the campaign to eradicate the current stigma surrounding being poor, and particularly around being on benefits by setting it within a rights-based framework and the proper language, commit to a human rights-based framework of policy development impact monitoring that recognises the full range of human rights that the Scottish population is legally entitled to, including under international law, which includes the economic, social and cultural rights I have just mentioned. Presiding Officer, I would also ask the Scottish Government to consider poverty as a violation of human rights, taking into account our health record and, in some cases, our increase in poverty. The battle with welfare reform and austerity, which is being paid for by the poor, the sick and the vulnerable, is a woeful insight into what the future could hold for us all. Universal and egalitarian free prescriptions, free education and free healthcare go some way to tackling that poverty. So I would also ask the Scottish Government to highlight the deliberate refusal of the UK Government of all colours to incorporate the Covenant into domestic law as it was and is committed to. This on the back of William Hague's Fresh Start in Europe paper, which rips us out of the EU's social chapter, which has rights that protect pensions, equal pay, working time directive, gender and disability protection in the workplace. And, Presiding Officer, the DWP's according to DWP's own figures, households with the lowest incomes will be the most affected and have the highest average change. 83% of these households are in the bottom 3 deciles. These are the ones that are affected. Presiding Officer, I believe the poorest will pay for austerity, and this is not acceptable and it is a violation of human rights. I believe Scotland can be a beacon to other nations in the family of nations. I believe Scotland has a universal and egalitarian outlook, as explained in the description of human rights.
You must conclude.
I believe that Scotland, with a rights-based constitution, starting with an action plan and working with our partners like the Scottish Human Rights Commission and others across Scottish society and academia, will and can build a progressive and fairer nation.
Thank you. I now call Graham Pearson to be followed by Jimmy Day, and we're rather tight for time.
Thank you, Presiding Officer. First of all, can I welcome the Government's motion in respect of human rights and say how pleased I am the stated intention from the Minister to support Scottish Labour's amendment in that regard. For 3 years, the Scottish Human Rights Commission have researched and discussed getting it right, human rights in Scotland. As a result of their investigations, the Commission has concluded that despite progress and a relatively strong framework for human rights, Scotland needs a more systematic approach to human rights to ensure that what Scots experience is both positive and consistent. Since 2008, the Commission has been working with organisations in differing sectors to help raise the level of understanding of human rights. The Commission's 5 strategic priorities for the coming 7 years includes empowering people to realise their rights through promoting a greater awareness and respect for human rights, supporting the implementation of human rights in practice, improving human rights protection in Scotland through influencing law and policy, progressing the realisation of human rights of people in Scotland beyond and through further developing our international role, and finally ensuring that the Commission itself is effective, efficient, professional and accountable. Human rights does and should reach every person and every institution in Scotland. However, in a short speech, it's necessary to focus on a few issues only, and for today, my issues will be victims, the right to work and prisoners. It's important that the services and support network available to victims focus on more than merely obtaining victims' money. Whilst receiving funds at a difficult time is obviously important, there are other significant challenges that victims face as well. Help and support is required, and their rights need to be respected, and this is why I welcome the Victims' Bill, which the Scottish Government is due to introduce shortly. In 2011, Scottish Labour Manifesto, the party committed the application of the human rights agenda to a practical effect, and to that end we called for the establishment of a Charter of Victims' Rights, the establishment of a Victims' Commissioner to champion the enablement of that Charter, the widening of the scope of the Victim Notification Scheme, and the work with the Scottish Sentencing Council should begin to simplify the current complicated system of discounts to increase the chance that victims and others would understand sentencing and what sentencing actually meant. And finally, of course, the establishment of the Victims' Fund. In the area of the right to work, there has been considerable criticism from charities and Scottish Human Rights Commission regarding the manner in which welfare reform is being undertaken by the UK Government. The consensus is that the approach is resulting in a retrogression in the realisation of human rights, particularly amongst vulnerable and marginalised people in Scotland. The Commission declares they believe that a human rights-based approach should both inform the analysis and the responses to economic crisis, offering an objective base for fair decision-making.
Please begin to conclude.
It's important that we recognise that people also have a right to work, and that right gives them a sense of well-being and an ability to play their part.
You must finish.
I commend the Government in bringing forward their motion and will vote in support of the motion and the amendment in due course.
Thank you very much.
Presiding Officer.
Jimmy, just to be followed by David Stewart.
Thank you, Presiding Officer. It gives me great pleasure to contribute to this debate this afternoon and to follow the thoughtful contributions that we've already heard from Graham Pearson and Christina McKelvey. The Minister spoke about values and about an international framework of human rights law. And as an international community, we have proclaimed that all human beings are born free and equal in dignity and rights. Perhaps it is the importance of these values that the international community needs to be reminded of today. Just a few days ago, the world witnessed a brutal massacre of 65 innocent civilians in Aleppo in Syria. This incident represents just the latest in a long line of human rights abuses in that country. It moved the UN peace envoy, Lakhdar Brahimi, to declare that the Syrian conflict has now reached unprecedented levels of horror. These include a range of unthinkable abuses ranging from kidnappings and rapes to torture and executions. According to the United Nations, the ongoing slaughter in Syria has already taken 60,000 lives, with hundreds of thousands of people seeking refuge in neighbouring countries such as Lebanon. At the end of last year, BBC journalist Fergal Keane reported first-hand from the camps in Lebanon. He said at the time, people are living in pretty rudimentary conditions here, with no proper sanitation, no light, and for these children, no education. When you look into children's faces here, you see the experience of war they have carried with them. They tell stories of parents attacked, of air raids, of the experience of being shelled. Most people who fled from Syria came with only what they could carry and are now dependent on the charity of the UN. When he asked a mother of 5 how she feels about being in her new home,
he received the reply, "Death is better than this isolation." The raw, unparalleled and absolutely unjustified pain inflicted upon fellow human beings warrants the strongest possible condemnation from the international community. The United Kingdom Government has played a constructive role in highlighting the human rights abuses in Syria, in seeking a diplomatic solution and in providing humanitarian assistance through the World Food Programme, through support to the UN Refugee Agency and through support to relief agencies in the provision of medical services and supplies. However, the UK's claim to be a champion of human rights is undermined by the inhumane and unfair treatment of asylum seekers in this country, people who are themselves fleeing persecution. And research commissioned in 2012 by the Scottish Refugee Council, the British Red Cross and the Refugee Survival Trust revealed how asylum support rates are below most poverty measures, and with no income, destitute asylum seekers fall below even the UN global poverty target of $1.25 a day. Moreover, as confirmed by the Refugee Council, almost all asylum seekers are not allowed to work and are dependent on very limited state support. They are unable to access mainstream benefits or homeless services unless and until they are granted the right to stay in the UK. And according to the Refugee Council, asylum-seeking women who are destitute are vulnerable to violence in this country. Often asylum applications are refused on what seems to be an arbitrary basis, and data from the UK Home Office shows that most asylum claims are initially refused, some 68% in 2011, but a high number of refusals are then overturned at appeal, 26% in the same year, calling into question, and I quote from the Home Office itself, the quality of initial decisions. Article 14 of the UN Declaration of Human Rights states that everyone has the right to seek and to enjoy in other countries asylum from persecution. But that is the question that we are entitled to ask in this chamber, is why the United Kingdom is then unable to fully honour this pledge. Presiding Officer, as Scotland finds its own voice in the world, we have an opportunity to become a force for justice and fairness and to show our solidarity with people at home and abroad.
Paul Davies-Stewart, to be followed by Stuart Stevenson.
Presiding Officer, when the great historians of tomorrow, those yet unborn, meet in the Mount Olympic heights of our great universities to assess devolution, where will the chapter open? What will the points in time that really made a difference for ordinary Scots? Could it be Donald Dewar's electrifying but poetic speech at the opening of this Parliament, the fight to take children out of poverty, the establishment of free personal care or the smoking ban? I believe that the cross-party support for international development, not least in Malawi, will be up there in lights. I believe the work in human rights at home and abroad has been outstanding. The creation of the Scottish Human Rights Commission by this very Parliament, set up in 2008, is an example of that. Devolution at its best, outward-looking, internationalist, and fighting the corner for the powerless, the poor and the dispossessed. As veteran human rights journalist John Pilger said, we are beckoned to see the world through a one-way mirror, as if we are threatened and innocent, and the rest of humanity is threatening or wretched or expendable. Our memory is struggling to rescue the truth that human rights were not handed down as privileges from a parliament or a boardroom or an institution, but that peace is only possible with justice and with information that gives us that power to act justly. I'm very sorry, I'm really short of time. The Scottish Human Rights Commission has been a success story. In 2010, it received A status and recognised fully in compliance with the UN principles on status of national institutions, which brings us, we've heard, international recognition and speaking rights at the Human Rights Council and other UN bodies. In the same year, the Commission and Parliament hosted a National Human Rights Conference with an address by Mary Robinson, the former President of Ireland and ex-UN High Commissioner for Human Rights. And in 2011, Scotland was elected Chair of the European Group of National Human Rights Institutions. We undoubtedly, Presiding Officer, have a strong team of commissioners and staff, and I would like to place on record the recognition by Parliament of Professor Alan Miller, Chair of the Scottish Human Rights Commission, who is in the gallery this afternoon. He is a well-respected figure in the international human rights work, and his reputation projects influence on the world stage. As we've heard, the Scottish Human Rights Commission's report, Getting It Right, is a textbook answer on what's human rights. Adequate housing, fair pay, fighting fuel poverty, standing up for the victims of crime and disability action. And as Aung San Suu Kyi said, Within a system which denies the existence of basic human rights, fear tends to be the order of the day. Fear of imprisonment, fear of losing friends, property or means of livelihood, fear of isolation, fear of failure. And we all know that human rights institutions aren't perfect. And as the Joint Commons report in 2010 said, the European Court of Human Rights is in crisis. A backlog of 1,200 cases. The failure is, in part, a failure of national government to implement court judgments. We need more pressure on governments to implement conventions rights at national level. In conclusion, Presiding Officer, we've made good progress, but still have some way to go. In our justice system, there have been positive developments in children's hearings and improved service of victims. There are gaps, as we've heard. We have an increase in hate crimes, low prosecution in human trafficking, and variable conditions in detention centres. By adopting the UN National Action Plans for Human Rights, which are evidence-based, they help us develop ways forward to address these gaps. These plans be developed and strengths and weaknesses analysed. I look forward to the outcome of the participation stage this year. Let us aim for Scotland to pick up the challenge as a leading nation in human rights, an exemplar and best practice, not just in Scotland, but for Europe and beyond.
Thank you. I call Stuart Stevenson to be followed by Alison McInnes.
Thank you, Presiding Officer. I very much welcome this timely debate, and I very much welcome the work that the Scottish Human Rights Commission is undertaking in this policy area. They definitely do show the way for many others around the globe. Now, while I respect Jenny Mara's engagement in the subject of trafficking, it's well established and entirely proper, I would have preferred to have seen a broader-based amendment, because there are a large number of issues, and trafficking is an important but by no means the only one. It is proper in a short contribution to focus on a narrow facet of what is inevitably a wide subject. Now, I am once again going to talk about climate justice. It's a geographically wide topic, but relatively narrow in policy. It's one where the rich impose an inescapable cost on the poor. The United Nations Human Rights Council in 2009 recognised that, and I quote, "Human rights obligations and commitments have the potential to inform and strengthen international and national policy making in the area of climate change." Now, I very much welcome the progress that our government has made so far. Engagement in establishing a climate justice fund, which reaches out to many other countries, a memorandum of understanding with the Inter-American Development Bank, carbon capture work with the Republic of South Africa, Saltar, Commonwealth professional fellowships, and so on. There is a great deal going on. I also very much welcome the fact that President Obama has appointed John Kerry as part of his new administration. That's a very encouraging sign of potential for movement in one of the world's wealthiest nations. I had the privilege to hear John speak at a United Nations conference, and if he is able to deliver in government what he referred to in that speech, we will see real progress being made. Now, the Mary Robinson Foundation for Climate Justice is one that I track on a regular basis, lay out a number of headings. And the one I want to just pick up immediately is the one on gender equality and equity, because this is the one where the impacts appear to be happening fastest and the effects most directly have the potential to kill adults and more especially children. As temperatures rise across the globe, aridity follows. Crop failures are an inevitable consequence. And women in many of the poorest countries of the world are the front line. They are the primary farmers, now with less food, walking further for fuel and for water, absolutely living on the margin. Women in poorer countries pay the price for our higher standard of living. And we shall see migration and the inevitable consequence that much of that migration will be into countries only a little less poor. And I don't think a policy and practice of spreading the poverty around more widely is one that I think we can morally live with. We have to help countries mitigate the effects of climate change. The government is doing something on that. I hope all governments, including our own, will do more. We need to be committed as citizens and as governments to turn down the world's thermostat. I want us to be equipping others to act on mitigation. Now, let me end by acknowledging Labour's long-term record of engagement in human rights, and it's worthy of praise. The real challenge, however, is to address the constitutional issue so that we can do so much more. Presiding Officer.
Thank you. Alison McInnes, to be followed by Linda Fabiani.
Thank you, Presiding Officer. Developing a national action plan for human rights is a welcome way of ensuring that the human rights we assume we have are in practice assured. And as the Commission itself explains, we have a fairly strong legal and institutional framework for human rights, but there are gaps in the actual realisation of them. The most important thing then to strive for in developing the action plan is to make sure that it has relevance to people in the real world. Our human rights are not abstract. They are the basis for ensuring that at every step in our lives we are afforded the best possible opportunities, treatment and freedoms. In the very short time I have this afternoon, I'd like to talk briefly on two domestic applications of human rights where I believe we can and must do more. First of those is the right to education. Education is vital to help people achieve their potential, but for all the progress we have made, there are still too many youngsters missing out. We must do more to ensure that disruptive and challenging children are not excluded from school. Why? Because we know what often happens to those excluded from and disenchanted with school. They end up entangled in the justice system. I've recently had the chance to visit Polmont Young Offenders Institute and also to meet with a number of young offenders taking part in community justice schemes in the North East. And sadly, the personal stories I came across were all too familiar. Now, it's not a problem unique to Scotland, but neither have we done enough to find a workable solution. Children excluded from education at a young age, perhaps with behavioural attention issues, often end up in court and in prison. And being there means they miss out still more on the education that could make the difference to the path they are taking. So we must do everything in our power to ensure that no one misses out on the education that is rightfully theirs. And the second specific issue that I'd like to touch on is the delivery of services to vulnerable and older people. In this instance, it's not a question of what care services are available. On the large part, they are efficient and fairly comprehensive. It is the quality of those services and, crucially, the manner in which they are delivered. Unfortunately, pressures can mean that care provision is driven solely by financial considerations. And sadly, many members will be aware of the tragic case of Ken Maitland in Aberdeen, who had 106 different carers in a single year before his death last year. Clearly, that was unacceptable, but it is the type of practical thing that we can take positive action on to prevent happening again. Fundamentally, care provision, particularly for older and vulnerable people, must be focused on the individual. Being treated with respect and dignity is surely a fundamental right for anyone receiving care, and we owe it to them to do more to ensure it is a reality. The most marginalised and vulnerable in our society, some of those people mentioned in those examples, must be protected. Presiding Officer, the Liberal Democrats have a strong and consistent record on human rights. The issue is at the very heart of our party. We have a strong record in government. Here, Robert Brown was the minister who guided the bill, establishing the Scottish Human Rights Commission through Parliament, and at Westminster, where one of our first acts was to end child detention at Dungavel. We are pleased to support the government motion today and the Labour amendment. We absolutely commend the continued excellent work of the Scottish Human Rights Commission, and we look forward to the development of the National Action Plan. And the motion is also right to be outward-looking. Human rights are the concern of the whole world, and it's right that Scotland also does what it can to support them on the wider stage. I will end on a note of caution, however. We can't get complacent at home. Legislation in this chamber is becoming more careless in terms of its human rights implications. We saw it with legal aid and we saw it with sectarianism. I would encourage the government to take time to reflect on their own approach and ensure first and foremost that Scotland's laws and actions set an example in being open, fair and free.
Thank you. Linda Fabiani, to be followed by John Finney.
Thank you, Presiding Officer. You know, when we talk about human rights internationally, people tend to get it very quickly and look at places like Syria and recognise people don't have human rights. When we talk about it domestically, all too often it's with bad publicity. and Annabel Goldie alluded to that, about the erroneous statements that are sometimes made about who gets the benefit of human rights in this country. But the Human Rights Act has had a positive impact on the lives of many people right across the UK. It has been used to, for example, ensure appropriate dietary requirements for patients in hospitals and care homes. It's been used to prevent or remedy abuse or neglect of the elderly, learning disabled or otherwise vulnerable. It's been used to prevent disproportionate targeting of black or ethnic minority people by police and other authorities. And it's also ensured that children with special educational needs are not prevented from receiving an education. I'm particularly interested too in how our own Scottish Human Rights Commission investigates these things and comes up with recommendations, and I would commend very much the independent evaluation, which was Care About Rights, which has done much to inform those in the care sector about how people should be dealt with dignity. That's not to be complacent, though. I think we always have to monitor it. I think there's always things which can be improved. For example, the rights of a constituent of mine, an incapacitated adult, the right to have properly investigated perceived shortcomings in his care, which resulted in physical disability, and I'm working on that just now. But I do have concerns hugely about the impact of the welfare reforms that are coming up from Westminster on us. I have no time to go into all. I would suggest that people read some of the official report from the Welfare Reform Committee this morning. It's harrowing reading about how people are being treated. But I'd also like to ask about the rights of someone who has lived in a social rented property for decades, who has spent years turning their house into a home, only to be turfed out because of the imposition of the bedroom tax come April, with no consideration of the circumstances as to why there is a spare room, or indeed the trauma and expense of having to move house. I believe this is further stigmatisation of the social rented sector, and is that not in itself an attack on the human right of dignity? And I have to say it's a bit rich for Lib Dems to talk about legislation in this place when it is they and their coalition partners who are imposing these heinous acts from Westminster on people here. We had a witness this morning who said that he didn't believe we would wish to behave that way here in Scotland. I certainly don't wish to behave that way, and I hope that nobody else in this chamber does either. So the motion put forward by Rosanna Cunningham is about promoting and protecting human rights, Scotland, Europe and the wider world. And that in itself is supposed to be a recognition of the brotherhood of man. That's why we have to tackle trafficking in this country. It's why we have to tackle detention at Dungavel. May have stopped children being kept in there for any length of time, but that's just by punting them down the road to other detention centres south of the border. So that is not looking after human rights. I want a national human rights plan, but I want it to be meaningful. I don't want it to be eroded by people in Westminster who think that here in Scotland we wish to be cruel to people who live in this country and to deny them basic human rights and dignity. I'm not about that. I don't want anyone else in this chamber to be about that. So I would ask that everyone think on about how we can have meaningful human rights in a national plan.
Thank you. I now call John Finney to be followed by Gil Patterson.
Thank you, Presiding Officer. It's good to hear the Minister's reaffirmation of the values proclaimed in the Universal Declaration of Human Rights, and hopefully we'll hear that from the whole of the Chamber at the end of business today. The motion talks about inclusive Scotland, and I would want to know what the challenges are to that. We've certainly heard from Neil Finlay about blacklisted workers and the right to work. Well, that very clearly is a challenge. And also there's a challenge regarding safe work places, and with cuts to health and safety and a threat to the working time regulations, clearly there's challenges to the rights of workers there. Now, the biggest challenge, of course, comes from the programme of austerity and the cuts in public spending. And human rights bodies have asked the UK Government, Parliament indeed, and the devolved administrations to, and I quote, consider more effective processes for assessing. So it's less than helpful when David Cameron refers to equality impact assessment statements as nonsense. Politics is about priorities, it is about competing demands, and whatever our differences, hard fought for human rights cannot be a casualty. This is Scotland's first national action plan for human rights. It's Scotland's plan, it's not the Scottish Government's plan, as we've heard, and it's important that there's ownership beyond the Chamber and in the Chamber and beyond. The motion also talks about embracing the opportunities presented by Scotland's engagement in the wider world to promote respect for the universal and indivisible rights of all humanity. And I would ask that the Scottish Government bears that in mind in its dealing with regimes around the globe, not least China, Israel, and some of the shocking human rights abuses we've heard of late in the Maldives.
I wonder if my colleague would agree that it would be no bad... I'm sorry, Presiding Officer. Does my colleague agree, I wonder, that it would be no bad thing to remind people that there is a history of attention to human rights with reference to the Scottish weavers and the people who fought for fresh and good contracts and how in the Isles and so on. We've got a history of it. It's not new.
John Finney.
I certainly would agree with my colleague on that, and it's for that very reason that we must sustain them and see no erosion of these rights. This plan will resonate regardless of Scotland's constitutional future, and when we talk about the future, I for one am very disappointed that Patrick Harvey's amendment wasn't included, because it gave us an opportunity to touch on a number of areas there, not least what would be in a constitution and the discussions there around a constitution which would highlight important issues of civil rights. Some has talked about relevance. In fact, a number of members have mentioned relevance, and that is the key to this. It has to be relevant to people. The Scottish Human Rights Commission have talked about notable progress and said we can do better. And we do know, of course, that this chamber must pass legislation that's compliant, and as we heard from others, that the legislation, of course, is shaped by the courts. What I would say is that many are concerned that in this building that human rights remains with the justice portfolio. That isn't a criticism of the individuals involved. Rather, there's a view that this is something that should transcend all portfolios and actually be part of every committee. Excuse me, I'm delighted that the amendment I proposed to include a reference to human rights in the oath of new police officers enjoyed support across the chamber, and I think it's very important that we do see practical application. In the half-minute left, Presiding Officer, I'd like to mention one situation that the Equal Opportunities Committee are dealing with, and that's an inquiry into gypsy travellers, who seem to be the last group in Scotland whose rights are routinely disregarded by the public sector. We've heard some shocking evidence. That certainly needs to be addressed. There needs to be better promotion of human rights in areas that matter to people, in their homes, their neighbourhoods, workplaces, schools. Above all, it must be relevant. And we have heard this evidence from elsewhere of the success of this approach to human rights, and I wish the Scottish Human Rights Commission all the best with their work and ask for the fullest participation. Thank you.
Thank you. I call Gil Patterson, to be followed by Ian Gray.
Thanks, Presiding Officer. I welcome the opportunity to speak in this debate and to highlight our country's role in the world in defending human rights. In Scotland, we have a proud tradition and history of promoting and protecting human rights, not only for our own citizens, but on an international level as well. The principle of human rights is something that's taken for granted in Scotland, and that's why we have an obligation to ensure that our human rights are not infringed upon, whilst doing our utmost to take this message across the world. Scotland is an inclusive country and takes its pride in its diversity. That is Scotland that we envisage and strive for in all sides of the political spectrum. I'm pleased that the Scottish Parliament and Government is building upon this with the development of a national action plan over the course of the coming year. We may not be the pioneers in creating such a plan, but we do have the benefit of learning from those countries that have already developed their own plans, and I hope that we can offer something distinctive to meet the challenges that we face here in Scotland. Scotland, as current member of the United Kingdom, is a signed-up member of the Universal Declaration of Human Rights, and when we become an independent, as surely we will, this will still be the case, but with Scotland playing an even greater role. There are, however, occasions when people complain about the impact of the Universal Declaration of Human Rights on individual rights, and whilst these criticisms can sometimes be valid, in my view, I think we must look at the bigger picture. I believe that the overriding duty of the Declaration at a multinational level is to defend the most vulnerable and marginalised in society, and to protect the individual who may be persecuted by those in authority, simply to silence them. I share the concerns of the Scottish Human Rights Commission over the response of the United Kingdom Government to a global economic crisis, in particular the welfare reforms that it is introducing, and I believe that the concept of human rights should be at the core of the decision-making process. Those who will be affected the most will be the most vulnerable in our society, as I already explained, and I fully endorse the actions of the Scottish Human Rights Commission and the many other organisations who have raised this issue with the UK Government, and I hope for the sake of those in need and the UK Government takes on board these concerns. The Scottish Government has done, and this Parliament has done, a great deal to promote human rights on an international level, from working with other governments to combat human trafficking to highlighting the importance of climate change, which is increasingly becoming a human rights issue. In the run-up to the referendum, it is imperative that both those in favour of independence and those against put forward their visions as how best Scotland can help promote human rights, whether independent or otherwise. I believe that an independent Scotland has much to offer on the international stage, and that we will be able to build upon the actions that the Scottish Government has enacted. So therefore, I commend the Scottish Government's approach and this Parliament's long-running approach to these matters, and I fully support the motion in front of us. Thank you very much.
Thank you. I call Ian Gray to be followed by Roderick Campbell.
Thank you, Deputy Presiding Officer. Since all things Danish seem to be the political flavour of the week, I note that Søren Kierkegaard wrote, "Life can only be understood backwards, but it must be lived forwards." And rights are lessons understood from our past, through which we can better live our future. I once heard John Hume of the SDLP say, "If you want to see the foundation stones of the European Union, then look at the war memorials in every town in Europe." The politics of today might distort that European vision, but its fundamental purpose remains a continent so bound by social and economic ties that it cannot drag itself ever again into the abyss of total war. But post-war leaders, not least Churchill, learned another lesson too, that the internal legitimacy of the states of Europe mattered, as well as the relationships between them. Thus, the Council of Europe was created to make human rights legally enforceable by the adoption of ECHR in 1950. So, the European Union was created to ensure peace between nations, and ECHR was adopted to guarantee that those nations were and would remain democratic. So rights fundamentally underpin our modern civilisation, don't simply reflect society as it is, but shape what it will become. And that's not always comfortable or convenient, but then neither is democracy. And in the same way as we may balk sometimes at the outcome of democracy, we may balk sometimes at the consequences of human rights. I, for example, don't like the idea of prisoners having the vote, and many resent the freedoms that rights extend to some. But surely we never wish to see again the tyranny that the abrogation of human rights inevitably heralds. So we're complacent about our rights at our peril. And I think that includes those who would see them replaced by codified constitutions and written bills of rights. The universality, the international reach of rights, providing us with protection by dint of our common humanity rather than our common nationality, raises them to the highest importance. In this chamber, we have deliberately and knowingly fettered our sovereign power with human rights with which we must comply or see our legislative labours struck down. The First Minister made exactly that point in his recent speech on constitutions. But I think that the logic of that point leads you to ECHR as the best internationally based platform for Scotland, independent or not, rather than a national, not international, constitutional Bill of Rights. Annabel Goldie is quite right that most universal rights are qualified, and they have proven themselves adaptable to changing times, far more so than, say, the US Second Amendment on militias blocking gun control in the United States to this day. And I know the Scottish Government like to reference Jefferson and Lincoln, but surely the message of the current movie about Lincoln is not how easy the Bill of Rights made it to abolish slavery, but how hard. So we must proactively seek to actually apply our human rights to the issues of our day. That's why we need a commission, and that's why Labour's amendment on human trafficking is right to draw attention to that concern.
Mr. Asher, to come to a conclusion.
I believe in the state as a place where we can organise for the common good, but the interests of the majority cannot ride roughshod over those of the minority or the individual. Our rights must be jealously guarded and constantly implemented. That should be the task of the Commission, the purpose of the action plan as it develops, and the obligation of this Parliament every day.
Thank you. I now call Roderick Campbell to be followed by Patrick Harvey.
Thank you, Presiding Officer. Whilst I accept we can always do more, I think we should welcome the many positive things we've heard today about
Mr. Campbell, could you move your microphone right?
about the progress Scotland has made across the board in terms of human rights. And I welcome the comments that David Stewart and others have made today. It's worth noting that the Scottish Human Rights Commission has pointed out that a number of laws of Scottish Parliament have been cited as good practice in human rights and in their subject field. However, it's fair to say that while we have effective structures in place and that various actions have been undertaken, including the development of the National Action Plan, we need to work on our outcomes, which the Scottish Human Rights Commission say decreases in influence the closer to real life we look. Of course, as all students of human rights will know, the traditional focus in human rights, certainly in the UK, was to look at human rights in terms of political and civic rights. Economic, social and cultural rights have played second fiddle, a point recognised by SCVO. But despite what Ian Gray says on that point, if we're to have a Charter of Rights or some kind of constitutional rights in an independent Scotland or legislation encompassing human rights, then I think there's plenty of scope for Scotland to lead the way. I personally take a different view to Mr Gray on that aspect. But it will be interesting to see whether any British Bill of Rights which emerges from this UK government takes up the challenge in respect of economic, social and cultural rights. I would guess that it probably won't. In the limited time available, I'd just like to say a little bit about human rights in the context of caring for the elderly, particularly those with conditions such as dementia. Article 3 of ECHR states that no one should be subject to inhuman or degrading treatment. Article 8 makes provision to protect private family life. When people begin to lose control of their cognitive faculties and can become more dependent on their carers, wherever they may be, there's always a danger that their vulnerability may not be adequately addressed. In their report, Getting It Right, the Scottish Human Rights Commission detail their views on Scotland's treatment of the elderly in terms of dignity and care, and the report notes an interesting recognition of the importance of unpaid carers, something demonstrated recently by the Carers Parliament event. It also identified some areas for improvement. For example, it cited research in 2007 that showed only half of a sample of dementia patients in hospital had a recorded life history in their medical notes, something the SHRC has described as an important part of social care. Care of the vulnerable, and particularly the elderly, is one area where we can say with cautious optimism that we are making progress in human rights terms. The Charter of Rights for people with dementia and their carers in Scotland, produced in the last Parliament, whilst it has no statutory footing, certainly highlights the need to promote and protect the human rights of those with dementia and in reaffirming society's responsibility in ending discrimination. This is a human rights agenda in practice. We have heard from others as to the impact of welfare reform, and it certainly seems to me that the proposed bedroom tax, for example, and its impact, for example, on divorced fathers, certainly raises, at the very least, potential Article 8 issues. The Glasgow Disability Alliance also raised an important issue in their briefing on the right to independent living, and of course the First Minister has referred recently to the rights of the homeless. I'm pleased also that the new Oath for Policemen contains a commitment to human rights. These are all steps in the right direction. And we also need to recognise that under existing international obligations, states have an obligation to achieve progressively the full realisation of social, economic and cultural rights. So politicians and government everywhere take note. Human rights are not set in stone. The ECHR is a living instrument and one that all governments must respond to.
Must begin to conclude.
I believe the development of a National Action Plan is a positive step forward and an effective way to ensure that the human rights of old vulnerable people are embedded in everything we do. It's an important step forward. I support the motion and the amendment.
Thank you. And I now call Patrick Harvey.
Thank you. I very much welcome the work that's been done by successive administrations on human rights, both domestically and globally, both through the work of our colleagues in the Commission and through the Scottish Government and public bodies throughout Scotland. We need a human rights action plan which positively asserts the value of a human rights culture, as opposed to the all too often slightly resentful attitude that we do hear from certain quarters at Westminster. I welcome the amendment from the Labour Party as well. It raises important issues which deserve to be taken seriously right across the chamber. I'm glad that the government will accept it, but I have to say I think it's a shame that the Minister seemed to have so little time for the member who was moving it, in whose speech I could find nothing to disagree with, or indeed for the comments from Neil Findlay on some of the employment rights issues he was raising. My amendment, which John Finney referred to, not selected for debate, but available as ever near the back of the business bulletin for anyone who's interested, did seek to raise some other aspects, and it's perhaps not my usual style to lodge a motion praising the First Minister, but I did it this time in relation to his recent comments on the prospect for constitutional rights. I believe this is an important idea, one that we should take seriously. It's echoed again in the Scotland's Future document published today. I'll take one very brief intervention.
Jim Eady. Mr Reid, I'm sorry, could you speak to your microphone?
I wouldn't want to encourage the member to agree with the First Minister on a regular basis, but doesn't he agree that a written constitution is the perfect antidote to the unwritten parliamentary sovereignty of Westminster?
Patrick Harvey.
I reassure him on the first point. And I agree partially with him on the second, but I don't have time to go into it in detail at the moment. The document published today does indeed set out the proposal to embed a wide range of rights in a constitution for Scotland. And I think it's important to remember that there are a wide range of such instruments, not just the Universal Declaration. Members have heard about the covenants on economic, social and cultural rights, the Covenant on Civil and Political Rights. My amendment also mentioned the United Convention on the Rights of the Child. It's not an exclusive list by any means, not an exhaustive list. Today, of all days, when our colleagues in the Westminster Parliament are hearing some excellent 21st century speeches and some abysmal 19th century speeches on the issue of same-sex marriage, I think it would be important to reflect the UN Declaration on Sexual Orientation and Gender Identity, which seeks to globally, and Scotland could be contributing to this argument globally, seeks to protect individuals from homophobic and transphobic violence, prevent torture, cruel, inhuman and degrading treatment of LGBT people, decriminalise homosexuality, prohibit discrimination based on sexual orientation and gender identity, and respect freedom of expression, association and peaceful assembly for LGBT people. What an opportunity Scotland could have to contribute to this debate, not only domestically but globally. And this is not an attempt to exclude or extract Scotland from that international framework that Ian Gray was so right to talk about. This is quite the reverse. This is an attempt to embed Scotland into those rights, to ensure that those many people who I believe are out there who are open-minded about independence but not yet convinced can have the reassurance to know that they're voting for a country, for an independent Scotland that will embed these rights, that will prohibit future parliaments or future governments from abrogating or denying those rights. This is an opportunity that I think all members should take seriously. I look forward to voting for the amendment and the motion tonight.
Thank you. That brings us to the closing speeches, and I call on Murdo Fraser. 4 minutes, please, Mr Fraser.
Thank you, Presiding Officer. Well, this has been an interesting and very diverse debate. We've had some very thoughtful contributions, and I'm very taken with what Ian Gray had to say, although I did not necessarily agree with all of it. I'm sure everybody here, and pretty much everybody amongst the population, agrees in principle on the importance of upholding human rights both home and abroad. There is very little in the European Convention on Human Rights with which people will disagree. Basic rights to life, freedom from torture and ill treatment, freedom from slavery, the right to a fair trial, the right to private and family life, freedom of religion, expression, assembly and association. These are all key rights which we all believe everyone should be entitled to. We should also accept that there will be areas of disagreement. As Annabel Goldie fairly said, there will be issues of conflict of rights between individuals, for example, where a crime has been committed, and there is a conflict of rights between aggressor and victim. And we need to be careful how we interpret human rights. There are many who think the courts have gone too far in interpretation of these rights, for example, in paying compensation to prisoners for slopping out or indeed giving them the right to vote. And as Annabel Goldie pointed out, a recent YouGov poll showed that 75% of the population thought the Human Rights Act had gone too far and was being used too widely to create rights it was never intended to protect. But I wish this afternoon to spend most of my time looking at the international situation, because I believe we have a duty to promote human rights internationally, using our influence and our power as a trading nation. I think it's worth examining the record of the UK Government and indeed the Scottish Government in this field, just looking at a couple of examples in the time available. And the first example I would quote is that of China. Here we have a very important trading partner, but one where freedom of speech, press, movement, religion, sexuality and politics are all strictly forbidden. Execution and torture are regularly used by authorities against those who question the state. Between 5,000 and 8,000 people are executed every year. Now, as you might expect, the UK Government has been very vocal on the issue of Chinese human rights. On his first state visit to China in 2010, David Cameron made clear his concern about Chinese human rights and established the human rights dialogue between two governments starting in January 2011, an approach which won respect from the Chinese themselves. The First Minister made a state visit to China in 2009, describing it as the greatest country on earth. He has since made 2 subsequent visits, and I can find no record of him on any of these occasions speaking out on human rights issues in China. And famously, the Scottish Government played down the visit of the Dalai Lama to Scotland, the First Minister cold-shouldering him after supposedly coming under pressure from the Chinese authorities, who mentioned hypocrisy, Deputy Presiding Officer. And the second example is that of Qatar. This is a country where migrant workers are oppressed and homosexuality is illegal and punishable with up to 5 years imprisonment. Human Rights Watch say that the Football World Cup to be played in Qatar in 2022 will be, I quote, a crucible of exploitation and misery for poorly paid migrant workers. The Emir of Qatar is an active supporter of the Muslim Brotherhood and is widely believed that he also funds dissidents in Mali. The Prime Minister made it clear at the time that the location for the 2022 World Cup was announced that football is for everyone. No one should be excluded based on their race, religion or sexuality. But when the First Minister visited Qatar, he was full of praise for the country and, I quote, the remarkable similarities between our respective nations. Again, no mention of oppression and no mention of human rights. Who mentioned hypocrisy, Deputy Presiding Officer?
I'm afraid you must begin to...
There's nothing wrong, Deputy Presiding Officer, in promoting international trade. And some of the countries we deal with will be distasteful, and that is an added responsibility, therefore, on us to speak out when we see that. The track record of the First Minister so far on these issues has been a dismal one. I hope in the closing remarks we hear from the Minister for External Affairs, he will indicate a change of direction.
Thank you. I now call on Patricia Ferguson. 6 minutes, please.
Thank you, Presiding Officer. This has been a very interesting and worthwhile debate, and there have been some very interesting contributions from around the Chamber. And it is, of course, fitting that we debate this topic today, immediately before Parliament is asked to recommend that Professor Alan Miller be reappointed as Chair of the Scottish Human Rights Commission, a reappointment that I'm sure we all welcome. And I congratulate Professor Miller on his reappointment. Perhaps I'm jumping the gun a little, but I'm sure colleagues will not mind that too much. And I would thank him and his colleagues for their contribution to this issue as my colleague David Stewart did earlier. The debate today has been wide-ranging and has been informed by the many briefings members have received from a large range of organisations active in the promotion and protection of human rights. And it has been very helpful to hear of the issues those organisations wish to prioritise and the concerns they have articulated. We may not, between us, have been able to cover all of their issues, but being able to read about them will remind us in future to reflect on the points that they make. As my colleague Jenny Mara mentioned in opening, Scottish Labour has decided to prioritise the issue of human trafficking in our amendment today, and I will say a little more about that later, because this is an issue which we take very seriously indeed, and we are very pleased that we seem to enjoy the support of our colleagues across the chamber in that today. As other colleagues have mentioned, ECHR is of course enshrined in the legislation of this Parliament. Those involved in establishing this Parliament did not feel that we had to be independent to strive for the highest standards. Unlike the vision of the First Minister that Ms Cunningham portrayed today, many of us are ambitious that Scotland plays its part regardless of the constitutional settlement. Now, I had enjoyed the opening of Ms Cunningham's contribution, and she chose a very relevant quote to exemplify the fact that human rights are not just a matter for governments, but of course what governments do matters because of the example that it sets. Now, I mentioned, Presiding Officer, that we've had some very interesting contributions from around the chamber, and I would like to reflect on one or two of those. I think my colleague Graham Pearson was absolutely right to highlight the fact that victims need to be supported through the struggles that they will undoubtedly face. And he was also right to highlight the right to work and the attack on human rights that is being perpetrated in the name of welfare reform. And Stuart Stevenson was correct to mention climate justice, and he alluded to the fact that the poor are the worst affected and suffer because of our actions and our selfishness and often our greed. And the action taken by Scottish governments of whatever complexion in promoting through their international development policies some climate justice measures and some environmental mitigation measures, I think should be welcomed by everyone in the chamber. I was very interested in Alison Johnson's contribution this afternoon, and I would like to draw, Alison McInnes, I'm very sorry about that, his contribution this afternoon, and particularly the comments she made about young people being excluded from school. We've all seen young people who don't have school to go to and who instead are on the streets. Well, I would like to explain to the Chamber about a school in my own constituency, John Paul Academy, which previously had a very high exclusion rate and now has reduced that rate to practically zero. Nothing has changed except the will and the leadership to recognise that young people need help and support. Some need it more than others, and where it's needed, it is given. And I would encourage Ms McInnes, perhaps if she's in Glasgow someday, to come and visit. John Finney was absolutely right to recognise the plight of gypsy travellers. For a long time, this Chamber and our various committees have looked at this issue, but we never seem to have been able to tackle the issue in a way that means that people have their rights recognised and respected. And I hope that the work that colleagues in the Equal Opportunities Committee are currently doing will help to make sure that that happens. In an excellent speech today, a word of which I could not disagree with, my colleague Ian Gray made a very good contribution to the debate. I think Ian helped us all to focus on the fact that a written constitution has its difficulties too, and that perhaps we don't rush in to doing that kind of model, that perhaps we have to have greater consideration of what it is we want to see. And of course we have to think about our international obligations in that regard too, and our place internationally. Mr Harvey.
Patrick Harvey.
Would the member be willing to go even just this far? That the Parliament currently is legally prohibited from passing legislation which conflicts with human rights, with the Human Rights Act. If we're into a debate about what kind of Parliament this is going to grow into, can we not all agree that we want this Parliament to remain constrained in that way, we want governments to remain constrained in that way, and a constitutional debate is one way of achieving it?
Trish Ferguson.
Well, I think, as with everything to do with the Constitution, we have to wait and hear what the people decide, and I want to do that, and I want to engage in that debate. Now, as I mentioned earlier, in closing, Presiding Officer, Scottish Labour want to highlight in today's debate the issue of human trafficking. With the Commonwealth Games only 1 year away, it's extremely important that we get this right. We would like to see greater clarity in the law and the adoption of the Palermo definition. We think that would help to foster a situation where there could be better detection and prosecution and greater protection of victims' rights. Only last week, the Committee of the Regions sitting in Brussels agreed unanimously an opinion on the EU strategy towards the eradication of trafficking. One of the key elements of this strategy was recognition of the key role that local authorities, be they police authorities, local councils or health services, provide in both detecting at a local level and in responding to the needs of those victims. And I think that's something that we in this chamber want to see. I thank the Government for their support of our amendment.
Thank you very much. I now call on the Minister to wind up the debate. The Minister is Humza Yousaf, and you have 8 minutes.
Thank you, Presiding Officer. Earlier, the Minister, Rosanna Cunningham, quoted Eleanor Roosevelt. I will close by quoting somewhat closer to home. Robert Burns once wrote, "Man's inhumanity to man makes countless thousands mourn." In 2013, man's inhumanity can be witnessed on a daily basis all over the world, and I'll concentrate on some of that international aspects that were raised. Before I do, I would just like to commend the tone and large of the debate. Some fantastic contributions, I think, across the chamber, some of which have already been discussed, although I somewhat disagreed with Ian Gray's analysis, perhaps. I thought his contribution was fantastic. David Stewart, Gil Patterson, Christina McKelvey, Linda Fabiani, Alison McInnes, Patrick Harvey, John Finney, many of them making some fantastic, Annabel Goldie as well, some fantastic contributions across the chamber. But on the international, we are on a daily basis confronted by human rights abuses across the world. The tragic events like the likes of Palestine, Syria, as Jim Eadie so eloquently and John Finney eloquently pointed out as well. Even in Egypt, some of the new Arab Spring democracies, whilst they come to grips with democracy, are facing some of those fundamental challenges. But they make us realise that Scotland's strong and enduring commitment to human rights cannot be taken for granted. It places a responsibility upon us as a nation to ensure that other countries develop and maintain a similar commitment. I'm very pleased that we're accepting the Labour amendment as well. Jenny Mara has been vociferous, tenacious, I may say, in this issue of human trafficking, quite rightly so, as well as Christina McKelvey and others across the chamber. So I'm very pleased that we are accepting that. I'm looking forward to the summit reporting back towards the middle of the year to see what recommendations they come up with and then responding. My colleagues no doubt will respond on behalf of the Government. There is, of course, worldwide recognition of Scotland's commitment to democracy, the rule of law and fundamental human rights. Scotland uses its international engagement as an opportunity to help increase respect for and understanding of human rights worldwide, not through arrogant lecturing, not through kind of condescension, but actually through mature, even-tempered discourse with our international partners about how we can support their progress towards being states which respect and progressively realise human rights. And perhaps Murdo Fraser asked me to address a couple of points on that specific issue. There has been discussions with China. Cabinet Secretary for External Affairs and Culture here herself personally has mentioned Tibet as an issue with Chinese ministers, a sensitive issue, but handled sensitively. The First Minister himself, after discussions with Amnesty International, with the Scottish Human Rights Commission, has raised issues that are creeping up the global agenda, such as climate justice. The recently drafted China plan, which I don't know if the member has had a copy of, one of the 4 guiding underlining principles is human rights and the rule of law. So we're unashamed about our promotion of human rights, where and when we can do it. And he mentioned Qatar. And he said, the First Minister's been to Qatar, and, Muslim Brotherhood and something else about women's rights and so on, all important issues. I don't disagree. But does he not know that the UK government has signed this year as the year of culture between the UK and Qatar? Not only that, his point is that we shouldn't be engaging with unsavoury characters, as he describes it. Does he not have any shame at all that a UK Prime Minister is selling arms to some of the worst abusers of human rights in the world. Of course you can respond to...
I'm very grateful to the Minister for giving way. He will know, because I referred to this in my speech, that self-same UK government has spoken out very clearly against human rights abuses in Qatar. I searched in vain for any comments from the First Minister following his visit to Qatar about human rights. Can he correct the record and tell me what did the First Minister say about human rights in Qatar, or where can I find that reference?
Minister.
So it's okay to lecture about human rights, but then provide them with guns afterwards. Well, that's some logic that even I can't understand at all. On a practical level, developing those relationships, I think, cannot help but further increase the understanding of shared world values. On a practical level, it of course allows others to utilise our practical experience, whether it be through effective policing, good civic governance, low-carbon economic development, or better healthcare to improve the lives of people overseas. We are equally happy to open ourselves, and I think we have to be, opening ourselves to international scrutiny. In May, Scotland, as part of the UK, was assessed positively by the UN on our realisation of international human rights standards. Indeed, the Scottish Human Rights Commission, which is accredited, as we heard, by the UN as an A-status national human rights institution, spoke at that very meeting. A body created by this Parliament, it is hugely respected, and that respect was shown and shared by many members in this chamber, who also noted that, coincidentally, members will be voting upon Professor Alan Miller's renomination as chair of the Commission shortly. I'm not sure which way exactly he wants that vote to go, but we shall see soon enough. The Commission's international stature certainly puts paid to the notion that Scotland is too small to make a difference. On the contrary, it's our duty to be good global citizens to join debates on these issues. I thought David Stewart, in particular, made that contribution on that point incredibly well. I understand that increasingly at the international level, key actors are drawing a distinction between the progressive, mature debate happening here in Scotland and the reaction often witnessed down south whenever human rights are discussed. And Annabel Goldie made the point, absolutely rightly, that we have to do something to win the public over, and perhaps that will feed in to the discourse and the action plan. We want to have a different conversation here. Scotland has a good story to tell, be that, as Margot was saying earlier on, about it being in our history through the Weavers, albeit in modern day times. We have much to learn from others, but also much to teach as well. So we will continue to urge all states over the world to fully realise international human rights law and open themselves up to international scrutiny in the same way. Just as we have sought to engage in a positive fashion with human rights issues, so the Scottish Government tries to make a direct practical difference in the grounds to the lives of the most materially deprived communities in the world. Today we support projects, as members know, across 8 countries in Malawi, Sub-Saharan Africa and South Asia, making a real difference to the lives of some of the world's most vulnerable people. For generations, Scots have reached out across the world, building economic, educational and cultural links with countries such as Malawi. But today's human rights are increasingly focusing on environmental issues as climate change remains at the top of the international agenda. The Scottish Government has been active in championing the cause of climate change, something that was mentioned by Stuart Stevenson in his very good contribution. In fact, this agenda would not be as high up the schedule, the programme of government, if it wasn't for the efforts of Stuart Stevenson. Really, I think, as well as inventing the computer and the internet and everything else in the world, he also can lay a claim in bringing this agenda to Scotland and the Scottish Parliament, quite rightly, as well. It's early days, but we very much hope this work will bear fruit and contribute to improving some of the poorest communities internationally. In Scotland and overseas, the Scottish people do things, I believe, very differently, not because we're elitist or we're exclusionist, but actually trying to embed some of those international human rights obligations that sit upon us. Not merely because we can, but because we want to. We are a modern, responsible nation, preparing to join the global community of nations as an equal member. The Scottish Government is committed to creating a Scotland that realises human rights, and for Scotland to play its part to create a world where human rights of all are protected, respected and realised. This is a vision I hope the Chamber can unite around, and I urge members to support the motion.
Thank you. That concludes the debate on promoting and protecting human rights, Scotland, Europe and the wider world, and it's time now to move on to the next item of business, which is consideration of motion number 5541 in the name of David Stewart on the reappointment of the Chair of the Scottish Human Rights Commission. And I call on David Stewart to move the motion on behalf of the Scottish Parliamentary Corporate Body. Maximum 2 minutes. Mr Stewart.
Thank you, Presiding Officer. Parliament is invited to agree the motion in my name on behalf of the corporate body to nominate Professor Alan Miller to Her Majesty the Queen for reappointment for a second term as Chair of the Scottish Human Rights Commission. The reappointment process comprised 3 elements: independent evaluation, interview and nomination. The office holders supported by the SPCB are subject to annual evaluation, which is based on a number of set criteria, including, for example, fulfilling the functions of the post, managing the day-to-day running of the office, leadership and motivation skills and forward planning. A report on the office bearer's performance is prepared by the independent assessor and submitted to the corporate body, and this report forms part of information considered by the SPCB during the reappointment process. Turning to the interview, Presiding Officer, the SPCB sat as the reappointment panel on Tuesday, the 11th of December, to consider Professor Miller for reappointment. The panel members were Linda Fabiani, Mary Scanlon and myself. I would like to place on record my thanks to Louise Lowes for confirming by way of a validation certificate that this nomination is made on merit, following a fair and robust reappointment process which confirmed to good practice. Details of the information considered by the SPCB and their criteria on which Professor Miller was assessed have been set out in the report lodged by the corporate body in Spice. Professor Miller was appointed on the 3rd of March 2008 as the first chair of the Scottish Human Rights Commission. His first task was to establish his office and, in consultation with his 3 part-time commission members, the strategic direction of the Commission. The Commission, as we've heard in the earlier debate, has achieved much in its short life. On behalf of the corporate body, we wish Professor Miller and his Commission continued recognition and success, and I firmly move this motion in my name.
Thank you. And the question on that motion will be put at decision time. And we come to the next item of business, which is consideration of motion number 5537 in the name of Mary Scanlon on the appointment of member of the Standards Commission for Scotland. And I call on David Stewart to move the motion in Mary Scanlon's name on behalf of the Scottish Parliamentary Corporate Body. And you have until 5:30 to do so.
Thank you very much, Presiding Officer. I'm speaking the motion in my name, and as you know, Mary Scanlon is unfortunately ill today, and I've been asked to carry this out. The motion is that, as a member of the appointment panel, is to invite members of this Parliament to agree to the appointment of Ms Lindsay Gallanders as a member of the Scottish Standards Commission for Scotland. As members will be aware, under the Ethical Standards in Public Life Act 2000, members of the Commission are appointed by the corporate body with the agreement of Parliament. This is the first such appointment undertaken by the corporate body, as until the 1st of April 2011, the Commission was sponsored by the Scottish Government, and members of the Commission were appointed by Scottish ministers. The role of the Standards Commission, again as members will be aware, is to encourage high ethical standards in public life, and it does this by promoting and enforcing the codes of conduct for councillors and members of devolved public bodies. The corporate body sat as a selection panel on the 10th of December last year. The members of the panel were Liam MacArthur, Mary Scanlon and myself. From a very, very strong field of candidates, we were seeking the agreement of Parliament to appoint Lindsay Gallanders as a member of the Standards Commission. And then again, on behalf of the corporate body, I'd like to thank Louise Rose, who is our independent assessor, who oversaw the process and has confirmed by way of a validation certificate that the appointment process complied with good practice, and the recommendation of Lindsay Gallanders is made on merit after a fair, open and transparent process. Turning to the candidate finally, Presiding Officer, we believe that Lindsay will bring to the post enthusiasm, integrity and discretion, and a commitment to ensuring high ethical standards are upheld in public life. And I am sure Parliament will want to wish her every success for the future in a new role. Presiding Officer, I move the motion.
Thank you very much. And a question on that motion will also be put at decision time, to which we now come. And there are 5 questions to be put as a result of today's business. The first question is that motion 5535 in the name of Mark MacDonald on the High Hedges Scotland Bill be agreed to. Are we all agreed? Yes. The Parliament is agreed. The next question is that Amendment 556.2 in the name of Jenny Mara, which seeks to amend motion number 556 in the name of Rosanna Cunningham on promoting and protecting human rights, Scotland, Europe and the wider world, be agreed to. Are we all agreed? The amendment is therefore agreed to. The next question then is that motion 5556 in the name of Rosanna Cunningham as amended on promoting and protecting human rights, Scotland, Europe and the wider world be agreed to. Are we all agreed? The motion is agreed to. The fourth question is that motion 5541 in the name of David Stewart on the reappointment of the Chair of the Scottish Human Rights Commission be agreed to. Are we all agreed? The motion is therefore agreed to. The next question is that motion 5537 in the name of Mary Scanlon on the appointment of member of the Standards Commission for Scotland be agreed to. Are we all agreed? The motion is therefore agreed to. And that concludes decision time, and we will now move on to members' business. Could I ask members who are leaving the chamber to do so quietly, please? Pause to allow members to change seats.